Lordship, matter may be taken up immediately after motion, item Lordship.
Item number
63, Lordship, part heard matter, that IIT matter, Lordship, student.
Okay.
Deeply.
Item number 22, my lord. Your lordship may permit me to withdraw this, my lord, petition, my lord, since the process has been on, my lord, to appoint the principal on merit. So liberty may be granted.
Mr. P.G. Saigal, let us counsel for the petition. Press for withdrawal of this petition with liberty to file application. Who appears? Secretary Education,
Secondary.
MS P. Das, Learned Standing Council appears for the Secretary Education Department. The petition is dismissed on withdrawal with liberty as well.
This may come up for order next week. This is regarding midday meal rice of LPC. Next week.
Let's say pray for listing of the petition in the motion column. So it was filed on 24th of June, but it is not listed. I've checked, Lordship, there is also defective. Lordship, maybe on Tuesday or Monday, Lordship. Tuesday. Obliged.
Miss please, also to mention for listing one WPC, my lord, for admission, my lord. In this case, my lord, areas are not given to the petitioner, my lord. I'm saying this matter will be fixed in the next week, my lord, on Wednesday, my lord, 24, my lord, 24 July.
Have we done 25th?
25. Reply, please.
Lordship. Lordship, I beg to mention item number 30.
Item
30.
30. Yes.
Lordship, I'm appearing for the petitioner. I pray that this matter may kindly be taken up after 2 weeks. I'm not well prepared today.
Okay, on request made by Ms. P. Agarwal, let us counsel for the petition. List up to 2 weeks.
Pleasure.
Wait, please, my lord. I beg to mention item number 50. I'm for the item number 50. I'm for the petitioner, my lord. I seek adjournment for 1 week, my lord.
Your good name?
W. Ahmed.
Item 50.
Yes, ma'am.
Your name is not there.
I'm for B. Chaudhary, my lord. On behalf of B. Chaudhary.
On request made on behalf of Mr. B. Chaudhary, let us counsel for the petition. When do you want? After a week?
1 week, my lord.
List the matter after 1.
Much obliged.
Yes, Gautam?
Lordship, I believe that on council is on DCO, Lordship.
May it please, your lordship. Lordship, I beg to mention item number 59.
59.
Last
Yes.
Lordship, I'm based in Delhi and I couldn't travel for some personal reasons. I'm seeking an accommodation today. Lordship, may kindly fix a date in August so that I can travel and do the matter.
I'm going to pray for next week, Your Lordship. Next week, if it
You want it next week?
next week, if convenient.
The other council wants it next week.
Lordship, next week it will be a little difficult because of some prior matters in the Supreme Court. So,
Give a date convenient to both of you.
Lordship, if I may propose 16th of August, Lordship.
That's a Friday.
Yes, Lordship.
Yes, Lordship.
Friday.
Twenty.
16 Friday.
For me, 16th August, it's okay. I don't have.
How about you? Okay. Your good name, please.
I, Hasib. Lordship.
Okay. On request made by Hasib, Learned Council for the petition. List the matter on 16th of August 2020.
Lordship,
Grateful,
appearance will
Lordship.
kindly be recorded.
Okay, MSP Agarwal, Learned Council appears for the response number 3, and Mr. Gautam,
For 1 and 2, Your Lordship.
Learned Council appears for respondent 1 and 2.
May it please, your lordship. I beg to mention item number 11, your lordship.
Item?
11, lordship. Or motion.
Yes.
I am for the petitioner, your lordship.
Oh,
The matter may be adjourned for the day and come up next week, your lordship.
11.
Lordship.
That goes with 12.
Lordship, and I am for the 11, lordship. Petitioners.
But it is listed along with item 12.
12 may be taken, that is another matter, your lordship.
Why is it listed together?
I don't know. I don't know, lordship.
The same petitioner.
No,
Yes. See your cost list.
as per instruction of my client, I have instructed.
Is the same petitioner.
Lordship.
MK
I-
Chaudhary.
Yes, I am not aware of the case, of that case.
Okay, wait
Well-
for some time. We'll see. We'll keep it in mind.
Lordship.
Please, your
Keep
lordship. I beg to mention item number 36, lordship. Can you pass over for the day load? Adjourn for the day load.
36.
36, lordship.
Your good name?
DC Nath.
On request made by DC Nath, list the matter after 1 week. Learning counsel for petitioner. List the matter.
Hey, please, your lordship. I beg to mention item number 23, lordship, on behalf of East Talukdar, lordship. 23.
Hmm.
He is suffering from illness today, lordship. He is suffering illness, so I prefer adjourn.
On request made on behalf of H. Talukdar, learning counsel for petition. List the matter when?
After 1 week, lordship.
After a week.
Must.
My pleasure, Lordship. I pray for listing a matter in admission, Lordship, on Monday, Lordship.
Not Monday. Monday is only good.
Lordship, this matter was last listed on 15/12, Lordship.
Yeah. 26th.
Obliged, Lordship.
Lordship, I beg to mention for listing petition matter in admission matter. Any date matter.
Admission.
Yeah.
29th.
Obliged.
I beg to mention item 1, 2, and 3 of today's daily list.
Yes.
Lordship, I appear for the respondent number 3. Lordship, my friend appears for the petitioner. I am praying for an adjournment of 2 weeks, Lordship.
1, 2, and 3.
Lordship.
Who appears for petitioner? Okay, Hurt MS K. Barbujari, learned counsel for the petitioners. On request made by MP Sharma, learned counsel appearing for the respondents.
3.
3. Respond number 3. List the matter after
2 weeks.
2 weeks. Yes.
May I please your lordship, lordship, item number 60 and 61 may be taken at 2 p.m.
60 and 61.
Yes, your lordship.
Why at 2 p.m.?
So my senior is on another court. Also, we have filed an additional affidavit yesterday.
Has it come on record?
Yes, your lordship.
Okay, we'll see.
No, sir.
May I please, your Lordship? Lordship, in item 57 and 58, there has been affidavit for dusty service has been filed, your Lordship. It may be allowed to be brought on record to the Lordship.
Okay.
Obliged, your Lordship.
Item 4 of daily motion.
Lordship, in this case, subsequent development has been made, so we need time to file additional affidavit, lordship.
You want to file an additional affidavit?
Yes, your lordship.
MS
G. Jain.
G. Jain, learned counsel for the petition, appearing on behalf of Mr. SCKL. Learned counsel for the petitioner submits that there has been some subsequent developments after filing of the present petition, and therefore prays for filing an additional affidavit. Stop. Praise allowed. How much time?
Lordship, 8 weeks.
8 weeks. 8 weeks
Lordship,
to file an additional affidavit.
some time may be given, lordship.
I'll give you 2 weeks time.
Lordship.
List after 2 weeks.
Sorry.
5.
Please, your lordship.
Yes.
Lordship, the matter is regarding transfer, lordship. On the last date, the respondent have stated that they shall take instruction because the process of transfer could not be completed due to the model code of conduct.
While the process is going on, my lord, within 7 days, my lord, order will be issued, my lord. Matter may come after 7 days, my lord.
Third MS A. Talukdar, learned counsel for petition. MST Chutiel, learned standing counsel, elementary, S Chutiel, learned standing counsel. Elementary Education Department submits that the process for transfer
My,
of the petitioner
my lord.
is being undertaken and therefore placed for a week's time to enable her to receive instructions. Praise the Lord. List after 1 week.
My. Obliged.
Much obliged.
6.
May please, your lordship.
Yes,
Well, as per the order, earlier order dated 24, my lord, 24th, my lord.
1 minute.
My lord. The matter relating to the release of my pensions. Uh-huh. Release of my pension and other benefits of my deceased wife, my lord. Now, as per the orders of your lordship on 24th, my lord, that we have to file an application. The principal didn't get it, my lord. But we have submitted before the inspector. They accepted it. The principal of the school, he didn't accept this one. Now they have forwarded the same. I think my instruction is this, my lord. They have forwarded to the government for release of PF and other this thing. Am I correct?
That instruction that I don't have, lordship.
That's what I've been told. Now,
I'll get it, lordship.
my
I'll
lord,
get it.
and another thing, my lord, what nowadays is that so the pension is concerned, pension and gratuity is concerned, my lord. The inspectors of schools, the office of the inspector of the schools has informed us yesterday, my lord, that unless and until we didn't get the no due liabilities certificate from the school, and school has informed the inspector of schools that that we have to go for an audit, and after completion of audit, we'll also issue no liability certificate, my lord. So my address prayer will be that, my lord, they should give a fixed date by the lordship may fix a date for the schools, my lord. They should complete and give the no liabilities dues to the inspector so that it can be processed, my lord.
The difficulties from the school itself. We don't have any difficulty so far as
So
department
far-
is concerned.
Yes, so far department is concerned, we are not. This is the school only, my lord.
Who is appearing for this principal?
It is only the school, my lord.
Their application by post on 3/7/2024, my lord. And they have already submitted their
My lord, I'll just before he did it, what this is, we have gone, my lord. They have not accepted, my lord. This is only the trouble has been made by the school only, my lord. My lord, the principal, my lord, it's the held responsible for that, my lord. And
They
that
have
is why we
already
have sent
submitted,
it
my
through
lord.
registered post, my lord. Now she'll come and say that on 3rd we have received this one by post.
No, they have already submitted their papers, my lord, on 27/6 before the inspector of schools, my lord. And
27?
Yes, my lord.
27/6.
my lord.
Before inspector of schools.
The petitioner submitted, my lord, but we have received their application, my lord, on.
What the learned senior council is saying is you refuse to accept the
That is the reason.
the thing, and then therefore he has no option but to send it by way of post, which you received on 3rd. Is it
My
not?
lord, they came to the office of they approached the office of the principal, my lord, on 27/6 without any order from the honorable court, my lord.
See, they do not accept that. I have to come with them for an order of this honorable court. See how they are acted, my lord.
They have not filed any application, my lord, and without any order of this honorable court, my lord, they have approached,
It's
my
the
lord.
right of me, my lord. How can it?
And the principal also not aware about the order, my lord.
Whatever it is, whether it is in order or not. Are you not supposed to take appropriate steps for release of the pension, gratuity,
My lord,
all this
after
audit report?
After that, my lord,
Unnecessarily, you're letting the petitioner come before this court.
after that, they had not, the principal, my lord, on phone, my lord, they call the petitioner, but they had not approached before, after that, they had not approached before the.
Okay, what are your instructions today?
My lord, this is the application, my lord, forwarded to the inspector of school, my lord.
That is not disputed. That is not disputed. Now, what is your instruction today?
My lord,
We'll
kindly
call the principal
about the
to appear in person.
non-liability certificate, my lord,
Let the
about
principal come to court. Then we'll pass appropriate orders.
my lord, about the non-liability certificate, that was, my lord, not signed by the principal, but that was, my lord, forwarded before the, my lord, earlier, my lord. Earlier, that was forwarded to the inspector of school, my lord. That was written in this forwarding application, my lord. Kindly see.
Let us see. Yes. You're acknowledging that they came before you,
Yes.
correct?
Yes.
So when you're submitting,
My lord, we have already submitted, my lord, my lord, earlier.
no, what is that, what certificate?
No due liabilities,
no,
my lord.
no
The
due-
inspector, the problem is not with the inspector of schools. They are cooperating, my lord. Only the problems of the principal is concerned. When we have gone, they have said that you don't have the court orders. So that is why we will not accept your so and so. Then we approached this. They have kept it. Now, yesterday, inspector of schools, office of the inspector of schools has said that they have to send the no liabilities dues. Now, what the principal says now, we will not send the no liabilities dues. We will go for audit of the entire audit. Then after audit, we will send it. That's
Yes.
what his stand is this, my lord.
My lord, 1 week time may be given, my lord.
For what?
1 week time for what?
My lord, for submitting of non-liability certificate.
Non-due liability. Are you sure?
Yes.
Okay. If on that day, if that no due liability certificate is
My
submitted,
lord, my lord,
then the petition.
sometime may.
No, why sometime?
My lord, I.
When did your wife die?
27/6. 27/6 June. 27 June, my lord. My wife.
This year.
This year, my lord, that has not been processed now as on now, my lord.
My lord, I have to inform about the.
That's why I'm
Headmaster,
asking.
my lord.
That's why I'm saying. I'll give you a week's time. Let the principal submit the non-due liability certificate within a week's time. After that, all trouble is over.
Oh, yes.
After that, everything will go to the inspector of school. He will do whatever is necessary, and the appropriate steps will be taken.
It's only because of the not signing of that particular document from the school matter is pending and delayed.
Yes. All right. Okay.
Okay.
Heard Mr. B. Boral and the senior counsel. assisted by Mr.
H.K. Sharma.
H.K. Sharma, learned counsel for the petition. Stop. The learned senior counsel submits that on the basis of the order dated 24/6/2024 passed by this court, the petitioner had approached the principal of Tahi Higher Secondary School
Respond number 5, my lord.
oblique respondent number 5 with an application for regularization of the absence period of his late
No.
wife. Stop. However, the respondent number 5 refused to accept the application, and therefore, having no other alternative, the petitioner had to send his application by way of post. Stop. Para. MS
R. Bora.
R. Bora, learned counsel, appearing on behalf of respondent number 5, submits that. No, on top again. Learned senior counsel further submits that the inspector of schools, that the concerned inspector of schools is unable to take steps, unable to take further steps, inasmuch as the non-due liability certificate is not being issued by the respondent number 5.
My lord.
Para. MS RR
Bora.
Bora, learned counsel appearing for the respondent number 5, submits that the application made by the petitioner was received by post on 3/7/2024. Stop. She also submits that the non-due liability certificate will be issued within a period of 1 week. Stop. Para. Recording the submission made by the learned counsel appearing for the respondent number 5, please this matter again on.
My lord, 2 weeks, my lord, kindly.
Now, why 2 weeks? What is so difficult to issue one non-due liability certificate?
I have to discuss about the matter, my lord.
You
Kindly
discuss?
2 weeks, my lord.
Wait, I'll give you, today's what, 17th. I'll list it on 26th, Friday, next Friday. That will give you sufficient time.
My lord, maybe 26, I have some problem, my lord. Absolutely.
29th,
My lord.
I'm giving you 2 weeks. This one,
Problem.
29th of July.
On that day, my lord, they will assure that
By the next returnable date, the respondent number 5 shall ensure that the non-due liability certificate should be submitted to the concerned inspector of schools.
I'm obliged, my lord.
7.
Status report is called for, my lord.
Yes, D not. Who appears? Yes, Begu.
Name is not shown in the post list, so maybe he missed the list item. After some time, I will inform the
My
lord.
lord, can it be on day after tomorrow? I'm suffering from high fever, my lord. Then
Day after tomorrow, there'll be some problem. We can have it on Monday or Tuesday.
My lord, Monday, my lord.
And on your request,
My lord.
on request made by Mr. M.A.I. Hussain, Learned Counsel for the petitioner. This is the matter on 23rd.
My lord. Hello,
That the registry is also direct.
status of the CID investigations, my lord, and in the
Reflect the name of the learned government advocate
My lord.
in the.
DNAT, my lord.
Okay, also directed to reflect the name of Mr. D. Nath, Learned
Senior
Senior
Government
Government Advocate in the process.
Hello, Ablash.
8.
Ma'am, please, your lordship. Here, my lord, I have received some verbal instruction. As per the last communication, uh, uh, arranged another land for the school, my lord. So sometime maybe another, my lord. Process is.
What is your instruction?
My lord, they have decided to give another land, my lord. For situation of the school, my lord. For shifting of the school, my lord.
So for our knowledge also concerned, there was some mutual understanding between
Yes,
the
my lord.
number 3 and number 5, Barbola. And thereafter, there is a decision to shift it in a conspicuous place where both the villagers, students will be
Yes, my lord.
number 1, Barbola.
So my lord, process is going on, so sometime maybe another.
But however, Lordship, the students are suffering, Lordship.
Already
Okay,
meeting
heard
was
Mr. Ardhar on council. MS N Fukon, London Standing Council, Elementary Education Department. Submits that the process to find out a convenient place
My lord.
to set up the school is underway. And therefore praise for
2 weeks, my lord.
3 weeks.
why not praise for 3 weeks time to enable her to receive appropriate instructions. Praise list of the 3
Date may
weeks.
can be fixed, Lordship.
9th August.
Upland.
Declare.
9.
May I please, your lordship? Your lordship, due to some, your lordship, in connection with this matter, your lordship, one file has not been available on records, your lordship. So I kindly grant some more times, your lordship. I'd like to place this, your lordship. Instruction. One connected record has not been found, your lordship. And that record is very much necessary.
Okay. Give her some time.
Yes.
Heard Mr. M. Sharma, London Council for the petition. On request made by Ms.
He does.
Pidas, London Standing Council Secretary Education. Department. How much time you require?
3 weeks time will be
3
granted.
weeks time is granted to enable her to receive instructions. List after 3 weeks.
Deeply obliged.
I may pray for a date, your lordship, subject to your lordship's convenience. After 3 weeks.
List on. Okay, 12th August.
Yes, I'm grateful, your lordship.
Deeply obliged.
10.
May I please your lordship? This matter relates to non-payment of my lord advance increment for acquiring the B.Ed degree as per this office memorandum of 1988. Now, my lord, so it was not provided that petitioner file a writ petition. And in writ petitions, petitioners were directed to file a representation before the director. And accordingly, he filed a representation, but that representation was not disposed of, then file a contempt. Then during pendency of these contempt petitions, they have come with an order that already that writ petition, that order has been complied with. And that is, my lord, in the 2022. That is 9/8/2022, page 66, my lord, your lordship's kindly see.
1 minute.
My.
Where's the order?
My lord, page 66, relevant page 67. Last paragraph, my lord. On the above facts and circumstances, the claim of the petitioners, that is, for granting one advance income for acquiring B.Ed degree cannot be considered at present. However, necessary follow-up action will be initiated on receipt of the government instruction.
On the above facts and circumstances,
My lord.
what have they stated?
Page 66. Contempt to 2023 statement. 1/5/2024. My lord, page 68, your lordship kindly say, see. Same respondent has already granted the same district the increment in 2021. My repetition was
This
disposed.
order was passed in 2020.
22.
2022. Why are you coming so late?
No, my lord, my contempt petition was pending. In contempt proceeding, my lord, this order was placed before this honorable court.
When was the contempt proceeding closed?
1/5/2024.
Where's that?
1/5/2020.
That they have not annexed, they just stated.
I have stated. Paragraph 16, I have stated. That 1/5/2024. That is in the month of May.
See, one thing is this, Chishti.
Yes, your lord.
The issue is, they've sent the proposal to the government
Yes.
Yes.
And that was.
and the advice of the senior, and the advice of the
Standing council.
standing council
At that moment of PS law on, yes, PS law, the vaccine.
was sought, which is still not to be given.
Yes.
Hmm.
That is.
But I'll have to take instruction regarding the subsequent development, whatever it is. I'll get it.
Okay,
May issue notice at this.
okay. Third, Mr.
And how?
N. Hawk, London Council Presentation. Issue notice. Mr. SMT Chishti,
Correspondent one.
Standing Council, Secretary Education.
Yes, second.
Appears for the respondent, 1,
3,
2,
4, and 5.
1, 3,
3,
4,
4,
and
and
5.
5. And my friend for 2.
And Mr. A. Chalial and Standing Council Finance
Yes,
Department appears for the respondent. Notice and respondents are complete, however, extra copies we furnished to, respondents are allowed to fill that.
Yes.
List.
After 3 weeks, 4 weeks, yes. 4 weeks.
Obliged.
11, 12.
11 to 26. Okay.
Yes, I think you made a mention.
Issue, yes, your lordship. Issue is different, your lordship, and the matter may be adjourned by the lordship today. There is some personal difficulties of my friend Mr. S. Ali.
Okay, that's fine, but Sharma, your matter is also tagged with this.
No, in fact, our writ petition 1025.
Oh,
There's an interim protection which was granted to us. Now, item number 11 is been conducted by a separate court of councils that we do not have any access and privy to the brief. So item number 11 and 12 being tagged together does not have the case of the petitioner's item number 11 also.
Petition is the same.
But might be the same,
Issue is different,
the set of conducting councils are different. Item number 12,
different.
lordship.
there was a stay granted in our favor in item number 12. That is as far as I'm aware of, the knowledge from the petitioners. Now, item number 11 is a new matter. We have no idea about that matter, your lordship.
I am seeking for item number
See, in item 11,
lordship.
there's an order of 14/6/2024. Have you gone it? Have you gone through the order?
No lordship, I am not aware of the
On the
matter.
prayer made by the learned council appearing for the parties. List this matter again on 17/7/2024, along with WBC 1025 of 20.
Lordship, I am not totally
That's how
aware of the
it's
matter.
like.
There is, there's
So,
in that item number 11. In the meantime, he wanted reputation to be disposed of. Have not stated about the case pending. Another case is pending. Only for dispose of the representation that was only. Because the pair is something almost similar as to the representation. That they have never stated there the case pending and the one interim order is already secured. That means securing an interim order.
Item number 12, your lordship, we contended that
12
being under suspension should be no bar for me to appear in the interview. Pursuant to that, we are granted a stay on a certain year, we are granted your lordship a stay on 28/2/2024. That is the end of the matter of item number 12.
No, that's not.
I am not aware of the case, your lordship, because this case is of Mr. S. Ali, his
No, that's fine.
lordship. So the matter may be adjourned for any other day, lordship.
1 minute.
Lordship.
Item 11, let's will produce the last page, 63.
That's it. Oh. Well, it appears petition is playing around with this court, isn't it? On first case, he comes to the court saying that I may be allowed to participate in the interview. The court said keep one post vacant.
Yes.
After he gets that order, on the basis of that order, he makes his representation, saying that to promote him to that post. As already there's one post kept vacant by the court. Now you promote me to that vacant post. That's what you want.
I don't know. I am.
You're not in the writ petition.
My name is here, but I am not aware of the matter, your lordship. Please. So kindly adjourn for the day, your lordship.
Okay. We'll adjourn it.
If item number 12 will be still tagged, your lordship?
Yes.
Yes.
It has to be.
Yes, absolutely.
Okay, on request made on behalf of Mr.
S. Hussain.
S.
S. Hussain.
Oh, okay, on request
On
made
behalf
by
of
Mr. S. Hussain and the counsel for the petitioner in WBC 3074 of 2024. List these matters after a week.
Lordship.
After a week. So, the interim order passed in WBC 1025 of 2024. This entry motor is absolute. So no need for
No need to, my lord. There is a one possibility keep taken, my lord.
cancel.
Deeply obliged.
13.
May I please, your lordship.
Hmm.
Lordship, matter pertains to non-payment of unutilized leave encasement benefit, your lordship. Lordship may direct the present petitioners to file separate representation before the respondent authority, your lordship. Similar order has been passed by your lordship in annexure 4, your lordship, page number 35, your lordship. And the observation is made on the fourth paragraph, your lordship, on page 38, your lordship. My lord, here communication has been sent, but instruction is awaited, my lord. Some time is required, my lord. Here. Lordship, it's a squarely covered case, your lordship.
You are the widows.
No, lordship, I'm the retired headmasters and assistant teachers of various high schools, your lordship, of Dhuri districts and Kokrajhar district, your lordship. Petitioners may be directed to file separate representation before respondent number 3, your lordship.
Yes, Sharma will dispose of this.
Sometime maybe granted.
The same thing, just directing them to make a representation, that's all.
That is their lordship, but only one issue, lordship. May kindly see page 13, prayer, lordship.
Page
13. Page 13, prayer, lordship. 1. To pay the petitioners for the maximum period of 300 days by calculating 30 days per year. Now, lordship, they are entitled to 10 days. That law has already been settled by this honorable court. They are not entitled to 30 days. But that is why lordship may kindly come to page 16, lordship. Page 16. Serial number 1, lordship.
Yes.
Lordship may kindly see column E.
Yes.
Maximum, that is the total accumulation, lordship, 300 days. 300 days. Next column 250 already sanctioned, lordship. So they have been paid eligible for 50 days, 50, that is the calculation. So only that clarification, lordship may dispose of this matter, but only clarifying that they are not entitled to 30 days, they are entitled to 10 days only. Sorry.
That will have to come by way of an affidavit. Otherwise, what I'm thinking is I'll pass an innocuous order. Just asking them to file a representation and then you will take steps as per law. That's all. I'm not giving a direction that you should pay 30, calculate at 30 days and so whatnot.
As per the position settled by, settled position of
Settled
law.
provision.
Oh, that's all. Third, Mr.
P. Daimari, your lordship.
P. Daimari, learned counsel for the petitioner. Also heard for the petitioner, sir. Also heard Mr. U. Sharma, learned standing counsel, Secondary Education
For
Department.
respondent number 1, 3 and 5, man.
1, 3 and 5.
5 and 6, man. Or 5, 5.
1,
Kokrajhar is.
3, 5
Or 1, 3 and 5.
and 5. How about 6?
6 is Kokrajhar.
Mr. H. Alia, learned standing counsel, Finance Department. For the respondent number 2. SSA.
Appearing for 4 and 6.
Okay, and Mr.
P.
P. Nayak, learned standing counsel, SSA
SSA
and
and
BTC. For the respondents, 4 and 6. Stop. Para. The petitioners before this court are the retired headmasters and assistant teachers of various high schools of Dhupri and Kokrajhar districts. And they are praying for directing to the respondents to pay the earned leave engagements benefits to the petitioners for a maximum period of 30 days by calculating 30 days, for a maximum period of 300 days by calculating 30 days per year after deducting the relief engagement benefits already paid for them. Stop. Para. After hearing the learned counsel for the parties and on consideration of the materials available on record, comma, this court is of the considered opinion that the ends of justice would be met if the petitioners are directed. If the petitioners file separate representations before the respondent number,
3, Your Lordship.
before the respondent number 3, oblique Director of School Education, Secondary Education, Assam, within a period of 1 month from today. Draft the respondent number 3 on receipt of the representation filed by the petitioners shall consider the same and pass a reason order to the respective representations of the petitioners in accordance with the settled position of law within a period of 2 months from the date of receipt of the said representations. So, with the above observations and directions, these petitions is disposed of. I think that should do.
Much obliged, Your Lordship.
14.
Also in the court list, matter is shown as higher education also, but matter relates to secondary.
higher device. In one case, it is shown as secondary, in one case, it is shown as higher. Second one, item number 15 is shown as secondary. But for, no, element different. Reliefs are different.
14 and 15 are same?
No, my lord, relief, 15, the relief is with regard to, my lord, that we want to be in the new, old pension scheme. We say that we are in the old pension scheme. And my lord, 14 is with regard to, my lord, pay parity, my lord.
Okay.
They are, my lord, basically postgraduate teachers. At this stage, only lordship will only issue notice. my
Yeah,
lord.
notice only.
Notice only.
Notice to window.
But Mr.
Second.
14 to secondary.
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 In fact, what has happened, they were, my lord, appointed as, my lord, they're all postgraduates, my lord. Now, they were, my lord, regularized in 2012, my lord. But while granting them a regularization, they were given only intermediate scale. Whereas, my lord, they are discharging the services of postgraduate, my lord, responsibilities of postgraduate teachers, my lord. It's the same post, my lord, in fact, same duties and responsibilities.
Mr. M. Datta, learned counsel for the petitioner. Issue notice. The secondary education is.
Secondary, my lord.
Mr. U. Shaman, and the standing counsel secondary education. Appears for respondents.
My learned friend will be appearing, my lord, for respondent number 1, my lord, 1, 3, and my lord, 4 to 9, my lord. 4 to, sorry, my lord, yes, 4 to 10, my lord. 4 to 10.
4 to 10 years.
And about 11 to 17.
11, my lord, 10 from, my lord, 11 is finance, my lord. 11 and 3, my lord. Sorry, 2, finance.
Okay.
2 is commission secretary finance and other
U. Shaman,
treasury
standing
officers, my lord.
counsel secondary education appears for respondents. 1, 3, and 4 to
1 to 4 to
10.
10.
10.
Yes.
Stop. Mr. A. Chalia, learned standing counsel, finance department appears for respondent number 2. And respondents 11 to 17. Notice on respondents are complete. However, extra copies needs to the learned standing counsel for this question. Respondents are allowed to file their respective affidavits. list after.
Tendency may not be barred for them to consider.
Tendency of this shall not be a bar for the respondents to consider the case of.
Right. Well, item number 15, my lord. My lord, they are, my lord, the same petitioners, my lord. What they are seeking, my lord, is, my lord, under the old pension scheme, the old pension scheme.
NPS and all pension.
Yes, my lord, because what had happened, they were regularized in 2012. They were serving from, my lord, 1998 onwards, my lord. And, my lord, it was those was in plan post.
Heard Mr. M. Gatal and counsel for petitioner, issue notice. Mr. U. Sharma, Learned Standing Council, Secondary Education Department, appears for respondents, one,
My lord, he will appear for one,
five,
my lord, one, my lord, then 5,
1, 5,
then 6 to
6 to
12.
1,
6 to 12.
Yes.
1, 5,
1,
6 to 12.
1, 5 to
12.
12.
5 to 12. Then, my lord, finance will appear in, my lord, in
Mr. H. Alia, Learned Standing Council, Finance appears for respondent number 2
13 to 19.
and 13 to 19.
My lord, 3 and 4, my lord, the accountant general and, my lord, the pension department. My lord.
Pension,
Pension and public
MS D.D. Barman, Learned Additional Senior Government Advocate appears for the respondent number 3, correct? 3,
Copy may be typed.
yes. How about Accountant General?
4, my lord,
Have you served a copy?
my lord, yes, my lord, I think names are shown if I'm not wrong, my lord.
Their names are not shown.
Names are not shown, my lord, but I think, my lord, I had but
Who was in Standing Council, Accountant General?
Mr. My lord, Chandra Borua, my lord, C. Borua, my lord. Mr. C. Borua.
Mr. C. Barol, Learned Standing Council, Accountant General appears for the respondent number 4.
Let's have a copy.
Notice on the copy. How about extra copies?
My lord, in item number 14, instead of higher education, our name may be shown, my lord. Secondary
In
education,
the cause list.
in the cost.
Respondents are not profiled. List after 4 weeks. In item 14, you just put registry is also directed to reflect the name of the Standing Council, Secondary
Secondary.
Education in the process.
Oblige, lord, deeply oblige, lord.
Yeah.
Where? Item 15. Registry is directed. 14 you are not there. 14 you are not there.
40 this is not there. In fact, 15. 15 SC AG is shown in fact.
In 15. So registry is also directed to reflect the name of the Learned Government Advocate as well as the Standing Council Accounting General in the process.
16.
Initially, the petitioner was appointed as stipendiary teacher on 4/12/1999, election 1, page 22.
Yes.
Page 22, subject with a condition that he will have to undergo the training, basic training, lordship, for regularization. Thereafter, lordship, if your lordship comes to page 23, at annexure 2, this is the order by which I was sent to undergo junior basic training, lordship.
Yes.
Thereafter, lordship, page 24, this is my certificate of junior basic training dated, which I had completed on 12/3/2003. Thereafter, my services was regularized. At page 25, this is the service book. Now, if your lordship comes to page 27, Srimati Sonashri Ramshiri, this is the petitioner. HSLC passed appointed as a stipendiary mistress against the converted post sanctioned by government order number so dated 1991 and posted her as Musalpur Junior Basic School by order dated dated 4/12/1999. Thereafter, lordship, she was deputed as lordship, that is not his necessary lordship. Thereafter, lordship, page 28, this is the regular scale of pay was given to her lordship with effect from 12/3/2003.
Yes.
Thereafter, Lordship, GPF statements, GPF accounts were also opened in the Office of the Accountant General at page 30. It starts from page 30, Lordship. Page 30. 30, 31, 33. These are the up to 2009, Lordship. Thereafter, Lordship, was surprisingly, in the year 2009, at page 36, my service was terminated, holding that my appointment is a doubtful, without assigning any reason. Up to 2009, I was continuing. In 2009, suddenly by order dated 23 June 2009, my service was terminated. Now, Lordship, if your Lordship comes to page 37, very interestingly, 22nd September 2015, the termination order was revoked and I was reinstated in service. May I read, Lordship? In pursuant to the Bodoland Territorial Council Executive Meeting Resolution number 4.1 dated 27/4/2015 and Resolution number 4 in the minutes of the Departmental Meeting of Education Department held on 26 June 2015 respectively, the Bodoland Territorial Council is pleased to withdraw the termination order issued by the order dated 6/11/2008 against Shonishwari Ramshari, that is the petitioner, Lordship, teacher, Mosalpur Junior LP School, in terms of the Director of Elementary Education, Assam, order dated 14/11/2006, with prospective effect. But I was up to 2009, I was continuing. 2009, I was terminated, and 2015, they have issued this, withdrawn this termination with prospective. Can it be, Lordship? Now, Lordship, interestingly, another thing, page 38, I have been appointed as tutor. Although I joined in 2015, as per the order dated 2015, I joined, but I was not paid the salary. Therefore, we filed a petition before this honorable court to release the salary, Lordship. That was not done. Instead of that, I was appointed as tutor by order dated 1st of April 2022. At the lump sum amount of rupees 10,800. Now, again, Lordship, page 39, this is the order dated 14 July 2022. May I read, Lordship? In exercise of power conferred, Lordship got it, upon the Director of Education, BTC Kukrajar, Vice Secretary, BTC's letter number so dated 13 September 2005, and in pursuance of approval of BTC Vice number dated 14 July 22, and Government of Assam communicated by number so dated 9/2/2021, the services of Shonishwari Ramshari, that is the petitioner, of Mosalpur Junior Basic School, who was reinstated in service by the order memo number so dated 1 October 2015, issued from this and is hereby regularized as assistant teacher, Vice Commissioner Ramshari, expired, and posted as Barampur Pilai LP School in the scale of payment of rupees so and other allowances as visible as per government. The said post has the approval of SIU Department, Finance SIU Department by order dated 02/02/2021. In terms of this order, Lordship, I joined my post at page 40. This is the joining letter. And joining was accepted by the principal in consultation with the SMC, School Managing Committee. But after 5 days, I was not allowed to continue.
When did you join?
On 18/7/2022.
Then
at page 40. This is the joining letter.
yes.
Now, Lordship, again, Lordship, at page 41, election 9. This is the letter from the Director of Education, BTC, to the Director of Elementary Education, Assam. Lordship, this is the letter, Lordship. May I read, Lordship? With reference to the subject cited above, I have the honor to forward herewith the proposal along with other relevant papers received from the DEO Baksa by letter under reference in respect With reference to the subject cited above, I have the honor to forward here with the proposal along with the relevant papers received from the DEO Baksa by letter under reference in respect of the following two of newly appointed tutor of LP school under Baksa district regarding accommodate as teacher instead of tutor, which were appointed as tutor by this office order dated 1st of April 2022 and order dated 1st of April 20 respectively, and as per approval by government letter number so dated 26/21. Now, after this, Lordship, the Director of Education, Director of Elementary Education wrote to the Director of BTC, Director of Education BTC at page 42 to take up the matter with the government, directly with the government. Now, at page 43, this is the letter written by the Director of Education BTC to the government, Commissioner and Secretary. Subject is letter dated 5th of January 2023 regarding matter of accommodation as teacher instead of tutor. With reference to the subject cited above, I have the honor to forward here with the proposal along with other relevant papers received from the DEO Baksa by letter under reference in respect of the following newly appointed tutor of lower primary school under DEO Baksa Musalpur in Baksa district regarding accommodate as teacher instead of tutor, which were appointed as tutor. That is the relation of the earlier letter, Lordship. But this is the letter which was sent to the government. But till date, no decision has been given. And I am returning on 30th of June 2025, Lordship. Now I am in the hanging position, Lordship. Neither I am here nor I am there. I was regularized in 2003. I continued up to 2009. Thereafter, I was whimsically with the colorable exercise of power. I have been terminated. Thereafter, 15 years with prospective effect, showing prospective. It cannot be Lordship. It should be from 2003 by.
Yes.
Related issue is pending, my lord. Yes, related issue. This.
No, this is that dispute is only regarding salary, not regarding appointment, Lordship. Here it is a separate case.
Pending.
That I have stated.
4126. In page 18, the petitioner already stated.
Yes, I have stated.
3273.
3273 2017 is
Yes,
pending
for-
disposal,
for
which is
the-
only for the salary, for the purpose of salary. No.
Purpose of salary for that intervening period
Yes, Lordship, that intervening.
where you were terminated and reinstated.
Again reinstated. Yes, that is so. And here the issue is that I have been regularized in 2003, thereafter terminated in 2009, again reinstated in 2015 with prospective effect. Then again, I was appointed as tutor without any basis. Thereafter, again on 22nd July 22, I was again regularized. I joined.
Yes, the respondent. As per page 43. Except respondent. Regarding this communication, my lord, so by the BTC, I have to take instruction, my lord.
See, the petitioner is retiring next year.
Yes,
My lord. Try to expedite, my lord.
because my pension will be held up, everything will be held up, Lord.
My lord, 2 weeks, my lord. Okay, heard, let me counsel for the petition. On request made by Mr. P.K. Bora, my lord, standing counsel, elementary education, list the matter on 2nd of August to enable him to receive instructions.
Obliged.
17.
Made please, Lordship. Okay, this matter pertains to selection and appointment to the post of junior assistant of the respondent college. My lord, a post of junior assistant fell vacant in the year 2021 due to the death of the incumbent. My lord. And for filling up that post, my lord, in the year 2022, an advertisement was floated for filling up one post of junior assistant under the category of UR
Where's
PWD.
that advertisement?
Well, your lordship will find at page 21.
Yes.
It says, my lord, as per the government letter, this may not be, my lord, relevant. The next is number of post library assistant 1, RP1, that is a roster point 1. The category was UR unreserved or PWD. So I
my lord, my candidature, my lord, I belong to a PWD category. I am already working in the college on a temporary basis. I submitted my application, my lord. I appeared in the written test and Viva OC, my lord. I was selected. But after selection, my name was forwarded for medical test, my lord. In the medical test also, I appeared, my lord. Everything was clear. But suddenly, my lord, after 2 years, my lord, after waiting for 2 years, they issued an impugn order on which your lordship will find at page 65, Annexure 8. If I may read, my lord.
Where's the select list?
My lord, select list is not there, but I may bring on record, my lord, this pending application, this medical test, my lord, which your lordship will find at page 659. This is the letter dated 6/6/2023, my lord. It was written by the principal chief superintendent to the director higher education. It says, my lord, with reference to the letter on the subject cited above, I have the honor to enclose here with a list of PWD candidates selected for the post of assistant professor librarian grade 3 and grade 4 in various provincialized PDO of government medical colleges of Assam for physics verification as per disability certificate by the medical board. This, along with this letter, some list was enclosed. My name is there at page 62, serial number 27. Serial number 27, madam. THB College, madam. This is the respondent college, Sonitpur. My name is Sanjeev Das, care of so-and-so, library assistant. And another letter is there at page 27, where my name is reflecting. Here it is written Annexure 3, page 27.
Yes.
It says, Malo, it was written by the THB College Jamuguri principal to the director. With reference to the letter number and subject mentioned above, I am to submit here with the below mentioned documents in connection with appointment of library assistant in respect of Sri Sanjeev Das. This is the, my lord, petitioner. The selected candidate under unreserved PWD category roster point 1. Well, this selection was set aside or cancelled by this letter. Just now I have shown to your lordship, page 65, letter dated 28/5/2024. It reads as follows. With reference to your letter on the subject quoted above, I am directed to state that as per your furnished proposals regarding approval of appointment of library assistant as unreserved PWD category, roster point number 1, while your letter is under reference, it is seen that the total number of cadre strength of grade 3 is 4, but you have advertised the post as per the roster point 1 on post-based manner without rotation of roster point as per 14-point roster system, which seems to be violation of rules and procedure in this regard. But there is no such rules, my lord. After the amendment in the year 2012, earlier there was a vacancy-based roster. Now it is a post-based roster, meaning there were, my lord, the post fell vacant in a particular category should be filled up from the same category of the person only, my lord. And this has been upheld by the, my lord, after the Supreme Court judgment in the R.K. Sabarwal case, 1995 SCC. It is clearly stated, pronounced, my lord, that the post-based roster means, my lord, the post, if a post falls vacant due to retirement or otherwise, that post has to be filled up from the same category person from whom the post was filled vacant. But the roster point was submitted, roster table, if I may take your lordship to page 29. The director asked for the roster point table from the college authority, and the college authority submitted this roster point table. Page 29. The serial number 1 post is reserved for PWD or unreserved. RP1 Bhavananda Bora, he died in the year 2021. After that, advertisement was floated. And 2, 3, 4, these are occupied by OBC, UR and UR respectively. But as for the roster point, the 5th point comes for STP. That is the roster point 5. Now the second advertisement, if I may take your lordship to the second advertisement issued by the department, page 66. serial number 2, my lord. This is the advertisement dated 21/6/2024, serial number 2. This is the library assistant, one post, roster 0.7, unreserved.
Roster 0.7, that
Unreserved.
is, you are.
Yes, my lord. My difficulty is that, my lord, since I appeared in the examination pursuant to advertisement published in the year 2022, at that point of time, my lord, I had the requisite age and the qualification. And by this time, when the cancellation order was passed by the authority, my age limit, maximum age limit, I have exceeded the maximum age limit. I cannot appear in the examination, my lord. Had there been a communication beforehand, my lord, I could have opted for some other employment. But the thing is that there is a gross illegality committed by the departmental authority, because the RK Savarwal case is very clear. The post if a post falls vacant, my lord, in a particular category, that post has to be filled up from the same category of person, not otherwise. Here the cadre standard is 4, it is understandable. But this cannot violate the mandate of the rule as well as the judgment passed by the Supreme Court.
Yes, Gwen.
This is a notice mail.
My lord, not noticed, my lord. My lord, I am praying for, my lord, the written test is scheduled to be held today, my lord. I am praying, my lord, as an interim measure, my lord. But the post should not be filled up, and the written test which is to be conducted today, my lord, the result should not be declared. Because, my lord, otherwise I am eligible, I was selected. Suddenly, after 2 years, they cancel my selection on the basis of post-based roster. And if I may take a lordship to the RK Savarwal's case.
No, that's fine.
Yes. And the rule is also very clear. The rule says, rule 5 clause 3 says, the post should be filled up from the same category of person if the post falls vacant due to death or retirement of a person belonging to a particular category. But the rule is very clear. They cannot do something which is beyond the scope of the rule, my lord.
No, it's subject to outcome like this. That because
No, not subject to outcome. Have you checked out the RK Savarwal's case?
I have to go.
Heard, Mr.
As Biswas, my lord.
S. Biswas, London Council for the petitioner. Para. Pursuant to an advertisement dated 19/5/2022, the petitioner who belongs to the PWD category applied for the post of library assistant. One post, is it?
Yes, my lord.
Under Rooster 0.1. Stop. After participating in the recruitment process, the petitioner was selected for the post of library assistant. In which college?
But Tyagbir.
No, on top, pursuant to an advertisement dated 19/5/2022, the petitioner applied for the post of 19/5/2022 issued by the principal THP College, Karchantula, Jamuguri Hat, Sunitpur. The petitioner applied for the post of library assistant. Under the PWD category. Stop. After undergoing the recruitment process, petitioner was selected. Stop. Thereafter, the petitioner also underwent the physical verification of PWD candidates. Stop. Then nothing happened.
No, my lord. After that, nothing happened.
Draft, while the petitioner was awaiting for his or her
His, my lord.
for his appointment order, the Deputy Director of Higher Secondary Education, Assam, by a communication dated 28 May 2024 and addressed to the principal, THP College, Sunitpur. On direction, stated that the approval of appointment of library assistant as unreserved within bracket PWD category within bracket booster point number 1 stated that the total number of cadre strength of grade 3 is 04. However, who is the principal respondent number?
4, my lord.
However, the respondent number 4 has advertised the post as per roster point 1 on post-based manner without rotation of the rooster point as per 14 point rooster system, which is in violation of rules and procedures in this regard. Accordingly, the proposal submitted for appointment of petitioner for the post of library assistant as per rooster point number 1 was
Cancelled.
was regretted. Stop. Thereafter, the respondent number 4 issued another advertisement on 21st June 2024 for the post of how many posts?
1 post, my lord.
No, for the post of assistant professor
Library assistant. my lord.
and library assistant. Stop. For being aggrieved, the petitioner is before this court by way of present petition. Stop. Para. It is the 40 case of the petition that the written test and computer test in respect of selection of the library assistant pursuant to the advertisement dated 21 June 2024 is being held today, i.e. 17/7/2024. Stop. Para. Issue notice. Mr. S. Bhuya, Learned Standing Council.
Higher education.
Higher Education.
1 and 2.
Appears for the respondents.
1 and 2.
Stop. Petitioner to take steps for service of notice on respondents 3 and 4 by registered post ID within a period of 1 week from today. Stop. Extra copies of which petition be furnished to the Learned Standing Council Higher Education within the course of the day. Respondents are allowed to file their affidavits. List the matter after 4 weeks. Stop. But in the interim, it is directed that the results of the written exam, written test and computer test in respect of the library assistant shall not be declared without the leave of the
The post may not be filled up. my lord. This will suffice for the satisfaction of the client.
Once it is, if the results are not declared, how
Yes.
can you
Yes.
fill it up?
Yes, yes, my lord.
60 of supplementary list, motion.
Yes, okay, call up at 2. 60 and 61.
62.
Wait, please, Your Lordship. Well, in this case, the petitioner before Lordship is challenging the impugned gradation list. Lordship find at page 62 to 26, my lord. Page 26, my lord. Well, the petitioner has been rendered to be junior to the private respondent, my lord. Lordship find the gradation list at page 26. I am at serial number 2, Lawrence Chandra Taka. And private respondent is serial number 1, Kalyan Das.
Yes.
Only on the basis of date of joining, my lord, he has been rendered to be senior. But Lordship may kindly see the background of the appointment. My appointment, Lordship will find at page 12.
Yes.
I was regularly appointed by the authority, my lord, after due selection. On, my lord, 30th October 1998. And the private respondent, he was appointed on 16th September of the same year, just 14 days, my lord, 1.5 months before the petitioner, but he was appointed on ad hoc basis.
Where is that?
Yes, my lord. I am reading the order, my lord. On recommendation of the district level selection board and subject to discharge without any notice and without assigning any regions thereof, Sri Kalyan Das BSc, an inhabitant of village so and so, is temporarily appointed to act as assistant teacher in PB 3.HS school in the scale of pay so and so plus other allowances as admissible under the rules on ad hoc basis for a period of 3 months. Then, my lord, his service was extended by order at page 15 for another period of 3 months. His service was extended. Second extension, Lordship will find that is, my lord, after a gap, there is a gap during the extension also, my lord. The next extension, Lordship will find it was extended on 13th of August 1999. For 3 months. And third extension, that is a final extension, my lord, page 19. Page 19. It was extended until further order. So, my lord, and his service was confirmed by the order at page 21. 12/8/2010. Page 21.
You also there, isn't it?
My lord,
Your name is also there.
my service was also confirmed, but my initial appointment was regular appointment. His initial appointment was ad hoc appointment. That is the difference. And for the
So you're regular, you're confirmed the same date.
yes, my lord.
Oh.
Confirmation is same date,
Mm.
but his service was on ad hoc basis prior to the confirmation, and my service was on regular basis. So, my lord, my past service can be counted towards my seniority, but his service towards seniority cannot be counted as he was appointed on ad hoc basis. On that count, my lord, I am relying on a decision of this of the apex court, my lord.
No, that's fine. That's when we proceed with the
Yes.
facts first.
So, my lord, thereafter, my lord, after retirement of the earlier principal, the school inspector of schools sent a seniority list to sent the improved seniority list to the director. Director considered the matter, and I was appointed as, my lord, in charge principal of the school. That order was challenged by the private respondent. Because I did not challenge the gradation list, I was rendered to be junior to the, my lord, private respondent. And that order has been, my lord, challenged before the division bench. The appeal is pending. The division bench was of the view that until and unless, my lord, I challenge the gradation list, I cannot be rendered to be senior to him. That is why, my lord, this petition has been filed, challenging his seniority, my lord.
Where's the order passed by this court?
This court passed the order, page 28, my lord.
It's a long order, my lord.
Were you a party?
Yes, my lord, I was a party, my lord. I was a party.
Hmm.
That aspect was not considered regarding the ad hoc appointment and all, my lord. While passing this order, that aspect was not considered. And on that ground, my lord, I challenged the order before the honorable division bench. The division bench was of the view that I have to challenge the gradation list.
Was the gradation list under consideration in that writ petition?
No, my lord. No. It was never challenged. It was never challenged by the petitioner, my lord.
No, was the gradation list under consideration in that writ petition?
No, my lord. Gradation list was not considered. Only point which was considered, that is the rule 13 of the conduct rules, my lord. He pursued 2 degrees, my lord, simultaneously without permission from the authority in violation of rule 13 of the conduct rules. That aspect was considered and
So your appointment as in charge principal was set
yes,
aside.
my lord, but still I'm working as in principal, my lord. That has not been implemented because the in the order, my lord, passed by the honorable single judge in the earlier round of litigation, there is a, my lord,
Respondent number 3, 1 minute. Okay.
this one of 4.
You have to respond number 5, isn't it? In
Yes.
in that writ petition.
Yes, my lord.
So what is there in para 28?
Yes, my lord, it has been typed as response number 3. It should have been response number
It
5.
should be 5.
My lord.
Anyway, that's a typing mistake.
My lord. But my lord, in paragraph 30, it has been directed to the authority to fill up the post, my lord, on in-charge basis by following the due process of law. By following the due process of law, my lord, one cannot be appointed as in-charge principal. If the law is to be followed, then the district-wise seniority list is to be, my lord, considered, and regular appointment is to be made. That is why this order has not been implemented till today, my lord. That has been brought to the notice of the honorable division bench by the State Council, my lord.
Yes, Kaushik.
Because the eligibility, my lord, even it is an in charge, my lord, the eligibility has to be followed, my lord.
But I as cycle and council for the issue. Mr. B. Kaushik, learned standing council,
Secondary,
secondary education, appears for the respondents, 1, 2,
1, 2, and 3.
1, 2, and 2. Petitioner to take steps for service of notice on respond number 4 by registered post edict within 1 week.
My lord.
List after 4 weeks.
I will be permitted to serve by dusty also, my lord.
Okay.
You can expedite the
within-
matter.
Within 1 week from the date stop. Para. Additionally, petitioner is also permitted to cause service of notice on the respond number 4 by dusty service to the registry of this court. Within a period of 1 week.
1 week.
1 week. After petitioner shall file an affidavit to that effect. Stop. List the matter up to 4 weeks. Pray for interim shall be considered on the next week.
But in the meantime, this graduation list may not be given effect to my lord.
That-
Because prima facie, my lord, he was appointed on ad hoc basis.
No, we'll see after he comes. Let the notice go or on the next week.
Also fix a date, my lord, in that case.
It will come. Otherwise, you can make your mention. I don't on the first day, if I fix date. it
My
will
lord.
be good.
My lord. Obliged, my lord.
Page 36. Prior to that, my lord, I have already, my lord, placed the background facts from beginning till the passing of the order day before yesterday, my lord. And I have placed also the list of dates, my lord, which will assist your lordships in gathering the factual background. Now, page 36 is the impugn order, which was passed on the date on which this honorable court was pleased to direct the IIT authorities and to allow them to participate in the end semester examination. Now, it says, dear Sri so-and-so, the undersigned is to convey that in connection to the unfortunate death of an IIT student, late so-and-so on so-and-so, your involvement in the incident and with reference to the letter communicated to you dated 31/1 so-and-so and show cause issued to you dated so-and-so, the institute has found that you had violated the following clauses of ordinance on code and conduct of students of the institute. Now quotes are mentioned and page 37 therefore, the following disciplinary actions have been initiated against you by the institute. You were expelled from the institute for a period from January 24 to June 24, and therefore your registration for that semester stands cancelled. You may be allowed to register in the subsequent semester from July 24. As an exceptional case and on special consideration, you may be allowed to participate in the next institute placement if you are unable to work out suitable arrangement with the organization if you are already placed. You are asked to undergo mandatory counseling for a period of 6 months and proof of the same has to be submitted to the institute. You are asked to engage yourself in social service activities of your own preference for a period of 6 months and proof of the same is to be submitted to the institute. However, prior permission should be obtained from the institute on the nature of the social service activity chosen by you. Now, this impugn order is challenged in the IA, my lord. So, prayer of the IA, if your lordships kindly take up page 20, setting aside and quashing of the impugn order dated 26/4/2024, which was a consequential order after filing of the writ petition, my lord.
One. Yes.
And my prayers in the writ petition, page 32, lordship will kindly come. 31/1/2024 is the letter by which penalty of suspension was imposed upon me. Page 32 are the prayers.
Statement बोला बार बार.
Yeah.
Page 32 are the prayers. First, the letter dated 31/1/2024, by which penalty of suspension imposed upon the petitioners, my lord. My lord, I am referring this as penalty of suspension. Why? That I'll, my lord, just explain after this. And show cause notice dated 5/4/2024, which already contains a finding that they are guilty. And how this honorable court dealt with this type of show cause notice, that I'll place before your lordships. then setting aside and quashing any other order in pursuance to the show cause notice, then mandamus shall not be issued directing the respondents to give 100% weightage in the end semester. Now I'll just take your lordships to the first order, that is 31/1/2024. Annexure P2, my lord. Page 37 of the writ petition, my lord.
Yes.
Second paragraph. This is impugned, my lord.
Yes.
Second paragraph, based on the interactions during the meeting, the undersigned is to convey that on approval of the competent authority, the following disciplinary actions, my lord, disciplinary actions have been initiated against you. Number one, a fact-finding committee is being constituted to investigate the entire incident leading to the untimely demise of late so-and-so, your association with the incident, if any. Number two, you are suspended from the institute with immediate effect until further orders. Now, number three, you are asked to vacate your institute hostel with immediate effect and to go home. So they not only suspended us, they directed us to go home. Now, lordship will kindly take.
Yes.
My lord is not having.
Yeah. I'll be back in this.
Fine, my lord. Absolutely fine. Absolutely fine. Huh? Well, have a seat, my lord, if he is not arguing, my lord.
It is
kindly, it's my
convenient,
request.
my lord. I'm not troubling anyone. I'm
No,
just
he's
writing
not
it down.
disturbing you.
It's not
This is not-
disturbing
this is
me,
the issue.
but that
How
we
my
do not.
learned senior is affected by that, I'm not sure.
Affected, my lord, we don't follow that when.
I'm just
Other
writing it
side
down.
is
It is
to-
easier to write it down on the desk. Right?
Fine, my lord. Now, my lordship will kindly, lordship has seen that you are suspended from the institute with immediate effect until further orders, and you are required to vacate your institute hostel with immediate effect and to go home. Now, lordship will kindly have the affidavit in reply filed in the writ petition, wherein I have annexed the ordinance and on code and conduct of students. Basically, this is the entire procedure. It contains the entire procedure, penalties, everything, my lord.
Affidavit in?
Reply, serial number, page 189, my lord. Page 189 would be the running page number.
Yes.
I'll directly take your lordships to the relevant provision. Lordship will kindly come page 197.
Yes.
Page 197, lordship will find 5E. Initiating administrator may dispose of a violation of by imposing any of the following sanctions, so and so. My lord, the sanctions are reprimand, from the appropriate administrator to the student on whom the penalty is imposed, placed in the student's permanent discipline record. Next is probation, written notification that further violations of any subsection of this code and conduct of student will result in more severe disciplinary action. Warning probation may be imposed for a period of not more than 1 calendar year. Disciplinary probation, written notification that further violations of any subsection of this code and conduct of student may result in suspension. The terms of the disciplinary probation shall be determined by an appropriate authority on case-to-case basis. Now, 5.4 is important, my lord. It deals with suspension of privileges. This is a suspension under the ordinance. This suspension was contemplated by the authorities to be a temporary suspension, like is placed under suspension and inquiry is going on. What it contains: suspension of privileges prohibits participation in or attendance at certain events, activities, or class/lab, restricts specific campus student privileges. Privileges means 5.4.1, hostel privileges, inter-hostel privileges, use of lab facilities. Next page, my lord, will find use of sports facilities, membership in club, other bodies, holding office, and placement activity. So suspension, if we go by the ordinance, a suspension can be, my lord, withdrawal of these benefits. It does not include ousting from the hostel, go home, not allowing to impart classes, not allowing to appear in the mid-semester examination. Suspension, normal suspension, pending an inquiry, does not include those. Now, what they have done, that is para 5.9. Suspension. Lordship's fine?
Yes.
Yes. Suspension, course drop, semester drop, rustification for a specified period may be given as a punishment depending on the severity of the offense. So type of suspension that has been imposed upon the petitioner is a punishment. And that was done on 31/1/2024. They say that it's a suspension pending inquiry. But the consequential actions taken in the guide.
1 minute.
I'm sorry.
Okay.
So the consequential actions taken in pursuance to that suspension lead to the conclusion that that suspension imposed on 31/1/2024 was not a suspension under 5.4. It was a suspension by measure of penalty under 5.9. So on 31/1/2024, without giving any opportunity of hearing, they imposed this penalty of suspension. That is, my lord, first submission. In view of that,
Come to 5E.
5E.
Yeah. So this is what you are saying. The initiating administrator may dispose of a violation
Yes.
by imposing any of the following sanctions
Yes.
without a hearing.
Without a hearing. So this,
under that 5E
without hearing,
comes 5.9 also, isn't it? Under 5E comes 5.9.
yes, under 5E 5.9, but 5.9, my lord, contemplates as a penalty, disciplinary action. It says, may be given as a punishment. I'll further clarify, my lord. If your lordships kindly come to 5.10 in the chart down below, SDC, that is the Student Disciplinary Committee. Reprimand, probation, suspension of privileges, restitution, compensation for damages, semester drop, rustication, expulsion, fines. So the moment, my lord, had they would have acted or had they would have, my lord, imposed suspension 5.4, no hearing is required. Fine, you are suspended from hostel privileges as because you have involved in some kind of indiscipline. We are conducting a hostel disciplinary committee inquiry. After that inquiry, whatever penalty will be imposed upon you. That procedure has not been followed here.
No, if 5.9 also can be imposed without a hearing.
In my respectful submission, no, my lord.
How? See,
It
because,
may come.
because under 5E, under 5E comes 5.1, 5.2 up to 5.10.
True, my lord.
Correct.
My lord, in E, it says about following sanctions. Impose any of the following sanctions without a hearing.
Hmm.
Now, it ends, and in 5.9, it says suspension, course drop, semester drop, rustication for a specified period may be given as a punishment depending on the severity of the offenses. You know, punishment has to be given after an investigation by the committee they have prepared. It was incorporated, my lord, 1, 2, 3, 4, 5 committees they have, my lord, formed to deal with several kind of offenses, my lord, or the indisciplines, my lord. So they themselves have said that if there is any indiscipline with regard to any particular kind, that will be placed before the committee. Committee will hear you and thereafter come to a conclusion what type of penalty is required to be imposed. Now, in my humble submission, my lord, 5.4 is fine. No hearing is required. But the moment you pass an order of suspension with the penal consequences that I'll have to leave the hostel, go home, and most importantly, the consequences that I'll not be able to attend class, I'll not be able to appear in the examination. This is, my lord, a punishment.
No, see, does.
Yes, my lord. That is my submission, my lord.
No.
Yes.
the
Yes.
5.E,
Yes.
5 clause E.
Yes.
It says initiating administrator may dispose of a violation by imposing any of the following sanctions.
Yes.
Any of the following without a hearing.
Yes.
Under that 5E comes 5.1 up to 5.10, correct?
Yes.
So 5.9 also can be imposed without a hearing.
My lord, in my humble submission, although it has says that sanctions, but 5.9 is not a sanction. It is a punishment. Sanctions are, my lord, suspension privileges, class lab restriction, campus student privileges, hostel privileges, inter-hostel privilege, use of lab, use of sports facility. These are minor in nature, my lord. So if these are minor in nature, Lordship will kindly take note of this, my submission, my lord. I'll further elaborate this, my lord. So my humble submission at this stage is that the moment you impose a penalty of suspension with the consequences that are done here, it becomes a suspension by way by penalty. It is not a suspension simpliciter, my lord, that you are holding an inquiry. Even if we ignore that portion of the question that has been paused by your lordships, that no hearing is required, even assuming, fine, no hearing is required, but this is a penalty. This is a penalty. As a punishment, it says. So, lordship will kindly mark that this kind of punishment, this kind of suspension is a punishment. So on the first day itself, on 31/1/2024, although they have said that they will ascertain the veracity of the allegations by a fact-finding committee, but they have imposed the punishment on that particular day itself. Because I have an argument of, my lord, double jeopardy also. So that's why, my lord, I am making a submission that this 31/1/2024 suspension is not a suspension simpliciter. It was a suspension by way of a punishment because of the consequential actions. Now, Lordship is aware that after this order, they have constituted fact-finding committee, SDC, and they just prolong the entire proceeding till the last day, that is 26/4/2024, on the date when they passed the order. Now, in the meantime, they issued a show cause notice dated 5/4/2024. My lord, that show cause notice is also under challenge in the present proceeding, that your lordship will find page 49.
Here on the writ petition, isn't it?
In the writ petition, page 49, my lord.
Yes.
Lordship will kindly come to the very first paragraph. Firstly, subject show cause notice under the provisions of the Ordinance and Code of Conduct of Students so-and-so with regard to the unfortunate date of an IIT Guwahati student on 1/1/2024. Number one, my lord, this is important. With reference to the letter communicated to you earlier, that is 31/1/2024, regarding the incident cited above, the undersigned is to convey that the institute has found you guilty of the following charges. Lordship will kindly mark this. They are terming it to be a show cause notice, asking us to explain what were the facts or what were the, because prior to this date, I did not even know what were the charges against us. This is the first thing from where, because prior to this, there were, my lord, SDC meeting, but charges formally that these are the charges against you were never communicated. This is for the first time we came to know that these are the allegations or charges against us. So this show cause notice itself contains a line which in which they demonstrate they have found us guilty of the following charges. Now, in this regard, my lord, there is a judgment of this honorable court dealing with the fate of such kind of show cause notice. I'm just placing the relevant paragraph, my lord. What should be the fate of such show cause notice? 2021 JLR 83. 2021 JLR 83. 83. What should be the fate of such show cause notice? That your lordship will find
Yes.
para 17. A bunch of writ petitions were heard by this honorable court, and para 7, may I read, my lord? Insofar as the case of Sri so-and-so is concerned, here also court is of the view that if the respondents wanted to take disciplinary action against him, then laid down procedure including principles of natural justice and fairness was required to be followed. Issuing show cause notice on so-and-so and directing the petitioner to submit reply on very next date cannot be said to be a fair procedure. Now, this is important. In fact, a perusal of the show cause notice would go to show that respondents had come to certain definite findings against the petitioner regarding involvement in corrupt practice, and he was only asked to show cause regarding removal from his contractual service. Such a show cause notice cannot be said to have complied with the requirement of principles of natural justice, and accordingly, show cause notice is set aside and quashed. So you cannot maintain a show cause notice which you cannot maintain a show cause notice which already contains some kind of finding with regard to the allegations. That is unfair, my lord. So in the page 49, they have termed it to be a show cause notice, and they said you are guilty of the following offenses. So in my humble submission, my lord, they acted in a preconceived mind. This is unfair, and on this count only, this show cause notice should be set aside and quashed, my lord.
1 minute. What does the show cause say?
Yes. Show cause, page 50, more interesting, my lord. The above violation, lordship will kindly mark it. The above violations resulted in the loss of life of the student. So, in the facts, the lordship will kindly appreciate the father of the late Aishwarya, he did not, my lord, lodge any complaint, any allegation against anybody. No police investigation, nothing. The autopsy report said that she died of lobar pneumonia. But the IIT authorities, my lord, they have become an investigator and they have found this conclusion: above violation resulted in loss of life of student. This is an addition to what has been said in paragraph 1. There is a finding. Now they purportedly say that 15 days time is given to submit your reply.
Yes.
So a show cause notice with a finding, in my humble submission, is unsustainable law and it is unfair, my lord. It depicts preconceived mind. Now, it is their stand that they have constituted a fact-finding committee which caused an inquiry. It is their stand, my lord. And it is an admitted factual position that a fact-finding inquiry, because 31/1/2024 letter also says that they are constituting a fact-finding inquiry. Now that fact-finding inquiry, my lord, after hearing us and whoever others we don't know, that fact-finding inquiry submitted a report. And basing on that report, this 26/4/2024 penalty order was issued. Now that fact-finding inquiry report was never furnished to the petitioners, my lord. The petitioners doesn't even know anything, what were the materials, what were the evidence against them for the IIT authorities to come to a conclusion that they have committed the alleged indiscipline. So, my lord, any decision without furnishing the copy of the fact-finding inquiry amounts to gross violation of principles of natural justice, my lord, and it's unfair. My lord, ECIL, your lordship's aware, B. Karunakar, the Honorable Apex Court in set clear terms has said that inquiry report you have to communicate. Be it a disciplinary proceeding against a government servant, be it a student disciplinary committee, whatever is there, that is the minimum requirement of, my lord, fairness in the procedure. The petitioners, they are entitled to know what you have collected, gathered, what were your appreciation during the course of fact-finding inquiry. They are entitled to know, my lord. So they never furnish the copy of the fact-finding inquiry upon the petitioner. So this is my lord, third ground on which this penalty order as well as the entire inquiry proceeding is vitiated, my lord. Now, lordship will kindly come to the affidavit again to the ordinance.
Reply.
Yes, my lord. See, it starts page 189 serial number. I'll directly take your lordships to page 194. Lordships, got me? Lordships, yes. My lord, serial number 4, disciplinary proceedings. Disciplinary proceedings could be conducted based on the nature of violations. Now 4.1 says composition of disciplinary committees. You know, there were various committees, my lord. Hostel disciplinary committee, HDC, one for each hostel. Institute hostel disciplinary committee, that is one IHDC. Then departmental disciplinary committee, DDC. Then institute academic disciplinary committee, AIDC. Then the student disciplinary committee, that is SDC. Now, para 4.3, my lord.
Yes.
My lord, these disciplinary committees were constituted to take or to investigate or inquire into various indisciplines, whether it is hostel level, academic level, or institute level. So all the committees are separate. Now 4.3, violation has been broadly divided into 3 categories based on where or on which context the same were detected. Now 4.3.1, hostel level, my lord. To deal with disciplinary matters at this level, there will be 2 committees, namely Hostel Disciplinary Committee, HDC, and Institute Hostel Disciplinary Committee, IHDC. Violation of general rules issued by Hostel Affairs Board by a hostel resident will come under the purview of the Hostel Disciplinary Committee. These matters are minor in nature and restricted to a particular hostel. So if in a particular hostel, some indiscipline rules issued by the Hostel Affairs Board are violated, then hostel level committee, that is hostel disciplinary committee, will consider those indisciplines. The HDC will deal with the matter and give appropriate punishment. For matters which have implications across hostels, they shall be referred to Institute Hostel Disciplinary Committee. So if there is inter-hostel indiscipline, then that will be placed before the Institute Hostel Disciplinary Committee. These matters are mainly related to the hostels only. Other matters which have major implications at the institute level shall be referred to the Student Disciplinary Committee. See below. The matters and the respective disciplinary actions recommended by HDC shall be referred to the chairman, IHDC, for approval. Similarly, matters and respective disciplinary actions recommended by IHDC will be referred to chairman, SDC, for approval. Upon approval, the charges will be intimated to HOS SA to the concerned people. Now there is another indiscipline, that is academic level. We are not very concerned with this. Even then, I'll just read 4 lines of it. Disciplinary issues related to the general conduct of the students in classroom and laboratory shall be dealt with by the Departmental Disciplinary Committee, DDC, of the concerned department. These matters are minor in nature and restricted to a particular department. So HDC, Hostel Disciplinary Committee, and DDC, these are minor indisciplines, my lord. Now, institute level, my lord. This institute level indisciplines are those wherein the SDC will come into play. Now it says 4.3.3 institute level. Violations at the institute level include those issues pertaining to the Indian Penal Code within or outside the campus. Lordship will kindly mark this. So my indiscipline will be an institute level indiscipline when it will involve Indian Penal Code within or outside the campus. In my humble submission, in the present case, my lord, there is no IPC is involved, no criminal case pending, nothing. But in spite of that, they took it to be an institute level indiscipline and conducted the inquiry by SDC, which is absolutely wrong, my lord. I'll just take your lordship to the remaining portion. Those that can affect the IITG community at large, or those that can affect the property of the institute itself. If we have damaged some property of the institute, then you can conduct an institute level inquiry or investigation by the SDC. For all such major acts of indiscipline, these are major, previous two were minor, which may have serious implications on the general body of the students and which may warrant a uniform and more formalized nature of investigation, SDC will investigate the allegations and recommend disciplinary actions. Committee may co-opt other members if they deem fit on a case-to-case basis. The charges recommended by the SDC shall be referred to the chairman, Senate for approval and will be reported to Senate. Upon approval, the charges will be intimated to HOS SA for the concerned people. Now, if your lordships kindly see the allegations in the instant case, for that, my lord, I'll take your lordships with the show cause again. It says, page 49, for an investigation by the SDC, the indiscipline that has occurred purportedly has to be institute level. Now, lordship will have to scrutinize where is the institute level indiscipline involving IPC. Then only you can go for SDC. Despite making plans in advance to attend a party in the city on so-and-so, you fail to obtain permission from the institute to leave the campus. Additionally, you did not comply with the requirement to log your details at the security desk register upon leaving the IIT campus on that day. So it says that we fail to incorporate the entry in the security desk register while moving out of the campus. Second is that according to the existing hostel regulations, you neither notified the institute nor took permission for your overnight absence from the IITG campus. Lord, it was our categorical stand from the very beginning, Lord. There was no decision for these students to stay overnight. Everywhere, my lord. There was no evidence before the IITG authorities that anybody has deposed that we plan to stay overnight, my lord. It was our categorical stand. Because had there been so, when we pre-booked the party, we would have pre-booked the hotel also. Because hotel was booked, it is their evidence also. Hotel was booked on that particular night when one of the friend was, my lord, he was unstable. So it says, according to the hostel regulation, you neither notified the institute nor took permission of your overnight absence from the IITG campus. At best, it can be an hostel violation. At best, I did not took permission from the hostel authorities, and hostel level violations, it provides hostel level. Violation of general rules issued by the Hostel Affairs Board by a hostel resident will come under the purview of Hostel Disciplinary Committee. So at best, this can be a violation of hostel to be inquired by Hostel Disciplinary Committee. Then why this SDC is involved? They could not have involved SDC, my lord. This is a procedural, they are violating their own ordinance. Now the next allegation, my lord. You exhibited inappropriate behavior while under the influence of alcohol, posing a risk to the health and safety of your peers. My lord, this was absolutely perverse. There was no material, nothing that we exhibited inappropriate behavior. On that date, the party was over. Petitioner number 2 was unstable. 2 girls were with us. So, taking into consideration the unstable condition of the petitioner number 2 and 2 girl students traveling from Guwahati to North Guwahati at that point of time, conscious decision was taken by all 4 that we'll stay back in a hotel and we'll inform the IIT authorities on the next day the circumstances. It was an accident that on 7:30 morning, Aishwarya died, my lord, because of the lobar pneumonia. So there was no material involving any Indian penal code to take these allegations to be an institute level violation, my lord. Then last is the information about a significant medical emergency and subsequent unfortunate demise to one of the students of IITG during the overnight stay away from the campus was provided very late by you. You know, this can never be a, my lord, institute level violation involving IPC, my lord. This can never be. So what sum and substance my submission is that even if we assume the allegations for the sake of argument that, well, these allegations are, my lord, correct, even then also you could not have initiated the investigation by SDC. Your own ordinance says that hostel level violations are to be dealt with by the hostel disciplinary committee. You are violating your own ordinance, you are exaggerating on the issue, and you have conducted the investigation done by an SDC, which is improper vis-a-vis the ordinance, my lord. And one more aspect, my lord, these hostel level violations are minor violations, my lord. It's incorporated in para 4.3, my lord. Now, so far as allegation with regard to not making entry in the security desk is concerned, my lord, I have also challenged these allegations to be perverse also. Our contention is that there was no material before the fact-finding inquiry committee to come to a conclusion that yes, we are guilty of these allegations. The first allegation is that we plan to stay outside. It was our categorical stand from very beginning that there was no plan to stay outside. Even if we produced the hotel booking by one of the petitioner, petition number 3, he booked the hotel at midnight, my lord. So there was no pre-plan to stay outside the hotel. So that allegation of yours that we planned long back to stay outside the hotel and to stay outside in a hotel, and we did not take permission from the hostel authorities, my lord, this is absolutely perverse, my lord. There is no material. Next allegation is that, my lord, you exhibited inappropriate, my lord, there is one allegation. You did not comply with the requirement to log your details at the security desk register upon leaving the IIT campus on that day. This is allegation that we did not log. My lord, we in our show cause reply, I'll just take your lordship with the show cause reply, what actually they have stated in their reply. They booked the cab came, and the person who is in the gate page 61, your lordship will kindly take up of the writ petition.
Which show cause is this?
This is show cause reply by petitioner number 1, my lord. My lord, replies are identical, my lord. One of the reply I have annexed.
Yes.
My lord, page 61, serial number 1. The allegation is first paragraph. Our explanation, though we have planned to attend a party in advance, we had no intention of staying outside during that night. So I did not fill the leave form in the hostel while leaving. This is the my lord, reply to not making entry. We booked a cab to the city and cab driver stopped at the main gate. We were about to get down to make entry in the register, but the security opened the gate, which clearly is the security personnel's directive that made us to leave without logging in. We left the campus thinking that it might be the same situation where the security sometimes does not ask us to make an entry while leaving to the city in campus bus service. So when they booked a cab. When they reached the gate, the security personnel opened the gate and they boarded the cab and they came back to the place. So is it not a slackness on your security? They are blaming us for not making entry. Why your security personnel allowed us to move out without making an entry? I have made specific averment in the IA that there was slackness, and what action you have taken against your security labs. We were petitioners, we were students.
But if you know the rules,
I know, my lord.
even if the gatekeeper or the opens the gate,
It happens, my lord.
you are supposed to go and do it.
True, my lord. It's true, and they are making a non-issue an issue. My lord, it was a 31st night, my lord. Students already there roaming around, my lord, because of the atmosphere on that particular day. Then when we reached the main gate, the gate was already open. The security person opened the gate and we went out. Had this incident would not have happened, that not making an entry would have been a, my lord, normal thing. You are making an issue, non-issue an issue because of the death of our friend. My lord, I have been to IIT, my lord. I have seen, for outsiders, yes, there is strict. If I go, then there is strictness. So I'll have to. But for students who stays there in the hostel, they come and move in and out of the each and every time. They are not required to make the entry. So that is the thing. So there is no material before the disciplinary authority or the SDC that we have done an institute level indiscipline in not making the entry for an investigation by the SDC and impose us such harsh penalty of expulsion from the institute. That is my humble submission with regard to this. Also will come. Since the penal orders is that perversity, my lord. Already I have shown your lordships that there was no material before the respondents to come to a conclusion that, number one, we have pre-booked our hotel. We submitted the hotel receipt also during the investigation to the authorities that we booked the hotel on that particular day itself. So there was no material to hold that allegation to be proved that we my lord, we have already planned our stay in a hotel. That, my lord, absolutely perverse, my lord. Subsequently, my lord, there was no material before the respondents that we exhibited inappropriate behavior. Milord, it's true, Milord. It was a 31st night. There were alcohol consumption, Milord. There is no doubt about it. They haven't denied before the authorities, Milord. But exhibiting inappropriate behavior outside the campus in the society, Milord, that doesn't mean, or there is no material that we exhibited inappropriate behavior. No complaint. There has to be complaint. Somebody has complained. Whether somebody has complained that we exhibited, is there any material? There is no material in my humble submission. So this allegation is also perverse. And thirdly, delayed information, Milord. We very specifically stated in our written statement that at 7:30 morning, when Aishwarya got the attack, we immediately took her to GMCH hospital by an ambulance, wherein the doctors declared her dead. In the meantime, one of the petitioner, he was kept in the hotel itself by the police authorities, because police authority was also informed due to the incident. So in that proceeding, some delay had occurred. As per their Milord record, they came to know at around 10:30. So from 7:30 to 10:30, Milord, there was a delay, and they have alleged that we have purposefully delayed. Milord, that is absolutely incorrect, Milord. There is no material before them to prove that fact that we purposefully delayed, going by the explanation given by the petitioners. Now, Milord, I'll just take your lordships to the impugn order. If your lordships kindly take up the impugn order that is in IA. A bare perusal of the impugn order reflects that there was no reason assigned, Milord. Page 36. Firstly, they say about the codes. They have given the codes of the ordinance, and thereafter abruptly the conclusion is the penalty. You are expelled from. Where is the reason? Where is your satisfaction? Where is the reason? Because any order having civil consequences, because it has got civil consequences, Milord, has to be backed by reasons.
Yes.
So this impugn order does not contain any reason towards satisfaction of the authority, IITG authorities with regard to the allegation, and number two, to determine what penalty you are going to be imposed. You have to, because you have imposed the highest penalty, expulsion, as per the ordinance. So you have to record reasons that going by the allegations and going by the materials available on record, these are the reasons for which we have come to the conclusion of imposing the highest penalty. So this impugn order is absolutely cryptic and non-speaking, and there is no reason assigned for satisfaction of the proof of the allegations as well as with regard to the quantum of penalty to be imposed. Now, Milord, my next point is, Milord, in the very beginning, Milord, I demonstrated before your lordships that the suspension, the type of suspension that was imposed by order dated 31/1/2024 against the petitioner, it was not a suspension simpliciter, it was a suspension by way of punishment because of the consequential directions that you did not allow us to impart class, appear in examination, did not allow us to give assignments, quizzes, and stop us from appearing in midterm exam. So it was a punishment. If that is a punishment, prima facie it appears to be a punishment, then again another punishment is amount to double jeopardy, Milord, for the same offense. Because expulsion is also a punishment under your ordinance. So this impugn order is hit by the principle of double jeopardy, Milord. That is one of my submission. Then, my lord, the penalty order, by the penalty order, they have given retrospective effect. The penalty order was issued on 26/4/2024, but they have expelled us from January to June.
Yes.
They could not have given retrospective effect to the penalty order. And one more ground I have taken in my writ petition, my lord, there is no positive answer or the answer is evasive. That is, in the ordinance, my lord, I have gone through, there is no provision for constituting a fact-finding committee. No provision. Yes, SDC is there, student discipline. If any indiscipline is there at the institution level, then it can be investigated by SDC. There is no provision for constituting a fact-finding inquiry. The constitution of the fact-finding inquiry was, my lord, alien to the ordinance. So this fact-finding inquiry and other SDCs, because at the very beginning, my lord, I submitted on 5/1/2024, when the first SDC meeting was, my lord, held, on that day itself, because they are students, my lord, they are not criminals. So they don't know how to withhold facts. Whatever, after the incident, they were asked to appear before the SDC on 5/1/24. On that day itself, they have disclosed everything. In fact, they have disclosed how many amount of alcohol they consumed in the party. To that extent, they have disclosed, along with the written statement before the SDC. So thereafter, constituting fact-finding committee and 2 SDCs, in my humble submission, is nothing but to prolong the entire proceeding so that they can drag it to the last date of, or they can drag it to the 29/4/2024. That is the date of examination of end semester, my lord. So that was the whole agenda, my lord. Otherwise, you have placed us on suspension on 31/1. You have taken a statement on 5/1. By January, you would have come to a conclusion, my lord. So in their affidavit, they take a stand. We did not, we have withhold facts, my lord. My lord, we did not withhold any facts, my lord. Whatever was known to us, we gave. In fact, my lord, while describing the facts before your lordships, day before yesterday, I have shown the annexures, how desperate they were to get an outcome of SDC, because they knew it, that their exams were coming. Now, my lord, in sum and substance, there are 4-5 grounds on which I have, my lord, challenged the entire thing. First is that, my lord, the show cause notice 5/4/2024, wherein they have already pre-decided that we were guilty of the allegation. And I have placed the single bench judgment of this honorable court before your lordships, wherein the status or the fate of such show cause notice has been laid down by this honorable court. Next is the report of the fact-finding committee, which was relied on by the SDC to frame the allegations to come to a conclusion, that was never furnished to us. Third is, my lord, the alleged violations, all those violations are hostel level violations. I did not take permission from the hostel. I did not make entry in the register of the gate. None of the violations were institution level violations, wherein SDC will come into play to investigate. So this entire investigation by the SDC is in violation of their own ordinance, my lord. Lordships, I am placing one judgment of this honorable court, that is 2012 5 GLT 386. 2012 5 GLT 386. This is Musabbir Hussain versus Guwahati University. My lord, in this matter, my lord, the BA degree of students was sought to be ripped off by the Dibrugarh University. And in that context, my lord, this honorable court, what has been held by this honorable court in such matters wherein the disciplinary proceeding is against the student. Para 13, my lord. Learned Senior Counsel, relying on the decision of this court in Noren Das versus Guwahati University and others reported in ALR 1973-49, has pointed out that while carrying out an inquiry of this nature, resulting in penal consequences affecting the future career of an individual, the principles of natural justice ought to have been followed by giving adequate opportunity of being heard. Apparently, such opportunity does not appear to have been afforded to the petitioners in the present case. The relevant extract of the decision in Noren Das Supra is quoted below, para 6. It is well settled that in an inquiry of this nature resulting in penal consequences affecting the future career of a student, the principles of natural justice have to be observed. The basic minimum of such rule is that the student should have an opportunity to know what the charges or the allegations are against him, on which the university wants to take action. He should have an opportunity to submit his explanation with regard to such allegations. If the such allegations are denied, there should be a proper inquiry, giving the student an opportunity to know the evidence that is laid against him. And if he wants to cross-examine any witness supporting the allegations, he should have the opportunity to do so. He should also have an opportunity to produce his evidence to rebut the charge, if he so desires. If the student wants to make an oral submission during inquiry, he should also have the opportunity to do so. The order ultimately passed, if adverse, should briefly contain the reasons for the same. The matter may be different when allegations are admitted. The above is ordinarily the procedure which will meet the requirement of natural justice, if thereby no specific rules on the subject. We find in this case that the petitioner was denied inspection of the answer script. He was not at all aware what facts were taken into consideration against him. It is made clear by the registrar before the court that some additional allegations were taken note of against the petitioner besides those mentioned in the show cause notice. There is therefore clear violation of the principles of natural justice in this case. The impugned order of the university is therefore quashed and the respondents are directed to forbear from giving effect to the same. Ultimately, relying on this, my lord, para 19, this honorable court had held, from the facts and circumstances discussed above, in the present case, there has been a clear violation of principles of natural justice by the respondents in awarding the punishment of so-and-so to the petitioner. Accordingly, writ petition is allowed, impugned order passed by the university set aside and quashed. So, there has to be fair procedure and compliance of principles of natural justice. You have called us to the SDC meeting, asked us to submit. That doesn't mean that you have followed. There are other limbs. Furnishing of the fact-finding inquiry committee's report is a sine qua non, is the most essential factor from where we could have come to know what were the materials against us, what evidence they have collected, what evidence the SDC had relied on at the time of framing of the allegations or at the time of imposing of the penalty, because they scrupulously, my lord, relied on that fact-finding committee's report till the last time. So in my humble submission, my lord, basically, apart from perversity, my lord, I am challenging the decision on the ground of violation of principles of natural justice and unfairness. Perversity is an additional ground on which I am banking upon to come to a conclusion that there was no material, it was absolutely a case of no evidence. So, my lord, from the very beginning, if I just sum up the factual situation, my lord, they got their job. They wanted to celebrate their job in a 31st day party. My lord, it's true that students should not consume alcohol. That's true. But unfortunately, assuming that we have committed a mistake, my lord, by consuming alcohol, but the allegations that are leveled, that we created an untoward situation, we purposefully delayed the information to the about the accident to the IIT authorities, that we pre-planned the hotel stay. These are absolutely, my lord, incorrect allegations. There is no material before the IIT authorities regarding this, my lord. So we, assuming that, my lord, we have committed a mistake, but does it mean that you will expel us? There were other penalties, my lord, because since it's a student institution, my lord, even if I do community service, that is also one of the penalty. If I do community service, that is also one of the penalty prescribed. The whole idea is to correct. It's not that we'll have to dislodge him. They'll have to ruin our career, because the situation right now we are in is that, my lord, we have got the job. On 15th of this month, we are supposed to join, but my instruction is that, my lord, some leeway time or buffering time will get to join. So, my lord, if these penalty orders are not interfered, which are apparently, my lord, in gross violation of principle of natural justice and other procedural provisions of the ordinance, my lord, our entire, my lord, career will be ruined. Their job offer will go. They'll have to again pursue the 8th semester in the IIT. And IIT authorities are sending mail to us that you take admission, you know, in the meantime, during the pendency of the proceeding, because July classes will start from 28th July. They are pressurizing us that you take admission in the semester, July to November. So, in my humble submission, my lord, although I know, my lord, things are a bit urgent in this matter, because if no decision comes, then they will remain hanging. So my humble submission with folded hat before your lordships is that some decision has to be there in this proceeding at an early date. And in view of my submissions, as well as the law laid down by this honorable court, the coordinate benches, this impugn orders, show cause notice, suspension order, and the penalty order, all three are required to be set aside and quashed, and the petitioners are declared, should be declared to have passed in their end semester exam. One additional thing I'd just like to point out, my lord. From January to April, that is till 26th of April, supposedly, my lord, when we approached this court, they kept us on suspension. Now they cannot have their cake and eat it too. You place under suspension, you did not permit us to appear in the mid-semester exam. Now you cannot come to a conclusion that we did not complete the entire procedure, because in the affidavit they have said that IIT has a particular module which a student has to fulfill for getting a result in the end semester or any semester. So that module or that stages like assignments, quizzes, we have to fulfill to get the result. Since we did not fulfill, they cannot declare the result. Something like stand has been taken. In my humble submission, you cannot have the cake and eat it too. You force us not to impart classes. You compelled us by suspending not to appear in the mid-semester examination. We wrote, I have taken your lordships with the annexures while showing the facts. We repeatedly wrote to the IIT authorities that take some decision at an early date, allow us to come to the institute. Our parents are worried, we are worried. So they did not us. So you cannot take benefit of your own action and disqualify us for this period, my lord. So basically, my lord, the entire proceeding is vitiated for violation of procedural provisions and violation of principle of natural justice. In my humble submission, this writ petition deserves to be allowed, my lord, imposing heavy cost upon the respondents for making an attempt of such nature, my lord. I conclude my submission, my lord. And deeply obliged for the patient hearing, my lord.
My lord, please.
Lord, I'll have a right to reply if required. Otherwise.
My lord.
Hold on.
Yes.
Yes, my lord. My lord, it is imperative that before I start, I have to address this honorable court with the nature of the institution which functions. This is not other engineering colleges which functions. It is an institute of national importance where students come to learn and research. Here, how the student is molded, their career and the nation's future is dependent. So before starting, my lord, let me just take this honorable court with the IIT Act so that some perspective can be put to this notice of the honorable court. Now, my lord, will see the act first. What does the act says? It is Institute of Technology Act 1961. Thereafter, I'm just taking to the relevant clauses, my lord. If my lord wants, then I'll brief the lord in entire this so. Now, para 6, my lord will see. Clause 6. 1. Power of the institute, my lord. Now, before I start, my lord, that has to be kept in mind. This institute is completely residential in nature. The responsibility of the students are in the hands of the teachers. They sometimes act as their guide, teacher, sometimes as their parent. If something happens to anyone within the institute, there is a responsibility, moral and both to the institute. Does institute maintain a full, very strict discipline so that no untoward incidents can happen? Now, my lord will see first para 6I. 6.1, my lord will see, and then my lord will go to power of the institute, and F will see. Let me read that. To supervise and control the residents and regulate the discipline of the students of the institute, and to make arrangement for promoting their health, general welfare, and culture and cooperative
and corporate life. So by the Act 61F clearly says that we are responsible and we are supposed to maintain the discipline, not only of one and discipline of the student of the institute, and to make arrangement for promoting their health. Here, ultimately, one person had died. At the end of the day, she was a brilliant student. That fact cannot be lost sight of, man. This entire proceeding is a proceeding where there was a gross misconduct on the part and of these petitioners. Their indiscipline has ultimately resulted into the death of the individual. Now, before going forward, my lord will see I thereafter. Next page, my lord.
Yes.
Sir. It has to be, I think, my lord will see 1 minute. Sorry, yes, I. To frame statute, ordinances, and to alter. I'm sorry, my lord, I'm not having the book, so that's a little difficult to remember. To frame statute, ordinances, and alter, modify, and rescind the same. So here, IIT Act gives us IIT the right to create its own statute, create its own ordinance, and this ordinance are at par, in my humble submission, is a par of are at par of a law under Article 13, my lord. So this is when this IIT forms an ordinance or statute, the petitioners are bound by that statute or the ordinances, and the relief which have been granted there or the procedure which has been granted there has to be followed. It cannot be said there is some policy document or an administrative convenience people had made it. Now, thereafter, my lord will see 14A. Talks about the functionalities of the institute and who is the chairman of the Senate. My lord had seen in para number 4.3.3, my lord, probably my learned senior was referring, that Senate chairman had to be intimated and permissions of Senate chairman has to be required. So this determines who is the Senate chairman. Senate chairman is the director of ex officio who shall be the chairman of the Senate, my lord. Thereafter, my lord will see para 15. That is the function of Senate. Now, why para? Let me just read the para 15, my lord, then I'll explain. Subject to the provision of this act, statute, and ordinances, the Senate of an institute shall have the control and general regulation and be responsible for the maintenance of standard of instruction, education, examination in the institute, and shall exercise all other powers to perform such other duties as may be conferred upon by it by the statute. Now, let me pause here for a moment, my lord. I will address this argument a little bit later also. To give the flavor, my lord, the argument made here is this, that even though I have not participated in the examinations and I have not completed the mandatory requirement, this honorable court must give me and pass grade. That, in my humble submission, is flawed, my lord. The only authority as per the act is competent is the Senate here. Now, my lord has to bear in mind that petitioners have neither challenged the IIT Act nor its ordinance or the statutes. The repugnancy of this are not under challenge in this law, in this proceedings. So whatever has been stated in the act or the statute or in the ordinance, that must be followed as per the letter of the law, my lord. Now let me proceed. And my lord, let me show clause 17. Director. Who is director, my lord? Director in each institute, my lord will see director. Director of each institute shall be appointed by the council with the prior approval of the visitor. 2 is very important, my lord. Will mark 2. Director shall be principal academic and executive officer of the institute and shall be responsible for the proper administration of the institute and for the imparting instructions and maintenance of discipline therein. So, my lord, the authority to maintain discipline as per the act is director, and thereafter the director's powers are in a way have been downstream by this SDCs and TDC. So my lord, then we'll take the statute, IIT statute, my lord. What IIT statute also talks about the power of director. I will just show one clause from the statute and then I will start my submission. Statute from 915, my lord.
Huh?
915, the statute 915, subclause 15, my lord. You take out attachment of 915, my lord has got?
Yes.
Yes. So, my lord will see, let me read it out. Director at his discretion can constitute committees and he may consider appropriate. So the power that this entire, that director has the power to constitute committees. In this case also, my lord, the fact-finding committees and all are being approved with the director, my lord. It is not the case where it has been projected that look, this committee doesn't have any power, doesn't have anything. I will show from the statute also, my lord, how they can be co-opted. These are all enabling provisions, my lord. So I'll pause here for a moment and then let me just give what has happened in between. Now, my lord will take down these dates. What happens in IIT, my lord? In 2022, 2012, 2022, the in-charge director, the IIT's regular directors gets, his term is over and new director, in-charge director has been appointed. Thereafter, on 26/10/2023, wait, what is the judgment? I'm just putting it as a part of record so that my lord can see. So what is, how, as I've shown, how the system functions, director's approvals are required, my lord. He being the chairman, so in-charge director was appointed in 10/12/2022. Thereafter, this in-charge director's appointment was cancelled by this Honorable Court's order dated 26/10/2023. And what was done on that, that it's some IIT Ropar at Punjab, his director was given an additional charge. This gentleman takes charge on 7/11/2023. And thereafter, the regular director of IIT is now appointed on 15/5/2024. Now, what happens here, my lord? This gentleman is traveling from IIT Ropar. He doesn't come every time. He is not at this campus located. An in-charge director and officiating director of another institute is coming. And sometimes he does this for a few days. He comes and he goes back. Now, I, as per my procedures, have to take his approval. Without his approval, I cannot proceed. My learned friend has shown that if the natural principle of justice is being violated, then this Honorable Court can interfere along with the procedural violations. Is it their case that I should not be following the procedure? It was never an intention of IIT. I will demonstrate from record now what has happened and how it is proceeded. It was never an intention of IIT, my lord, to delay the matters. But because there is an administrative inconvenience, because of this Honorable Court order, there was an in-charge director was taken out and this charge was given to IIT Punjab's director. He was not traveling here regularly. There was an administrative inconvenience. Thus, sometime it has taken for these committees to take approval. I will show from the now regular ordinances how this mechanism works. Show me the ordinance, please. Now, my lord will first, before starting, my lord, this flavor is required because then, my lord, I can proceed and address the point on A. My lord will now, my learned senior has attached the ordinance with the affidavit and reply. I think, my lord, the page number was. What is the page number of ordinance which they have relied upon? It is not the one. Sure. It was on one of the Yeah, my lord. My lord has got the ordinance, then probably. One 89 of the, no, yes. Thank you. 189 of the, my lord, petition. My lord will see. Now, my lord will take the first page, my lord, and see the first one, introduction. Before introduction, it says ordinance of on code of conduct. Students, my lord has got that line. Yes. Now, in between, my lord, first 2 lines, after the 2 lines, in between it starts the code of conduct. My lord has got that line. I'm only showing the relevant part, my lord, as of now. The code of conduct of the student outlines the student's conduct and disciplinary policies that pertains to the students and the students' organization at IITG. Thereafter, my lord, 1 to 3rd line in between, the purpose. My lord has got the purpose? Yes. The purpose of the policies outlined in the code of conduct of the student is to protect the rights of all members of the IITG community and to maintain an atmosphere in the community appropriate to the institution of higher education. That is the reason this code of conduct exists, my lord. Not everybody has to be benefited or not some 1-2 people who had done certain things. Now, thereafter, my lord, we'll see the next point, scope. I'm only showing the relevant parts, my lord. The scope. The students, my lord, has got the second paragraph by starting the student disciplinary system exists to handle infractions against the institute rules and regulation. The system is based on the philosophy of fairness of all parties affected by the situation involving a student's non-compliance with the IITG policy and regulation. The student discipline system is designed for an educational system and does not function as a court of law. Therefore, the procedural issues, including the introduction and consideration of evidence, are handled in a manner consistent with educational focus. I'll pause here for a moment, my lord. These people are not some experts in law. They are experts in their subject matters. These professors. They are not some lawyers or some legal experts or some legal luminaries. They are teachers and they function as a teacher. And to cover them and to safeguard them, that is the reason it exists in such a manner. The language is such a. Now, let me proceed a little bit further. Where the allegations are more serious and therefore the consequences are more serious, the rules are structured appropriately. The student discipline system is not a substitute for criminal and civil courts, but an additional option for the complaints when the alleged violator is an enrolled IITG student. The case has been made out, there is no police report, there is no police FIR, not required. I respectfully submit this, my lord. I will also show that violation of IPC is not required to initiate a proceeding under 4.3.3. Let me proceed further, my lord. And the last line, the last paragraph, my lord, 1 to 3rd line, starting for the word further. Further, if a student or a group of students is reported to the institute authorities for violation of off-campus, the institute may intervene on an formal or an informal basis. The informal intervention will involve the individual student or the group of the students being referred to the Dean Student Affairs or to the competent authority for discussion on the incident. Off-campus behavior, which can have significant impact on the mission of the institute, may invite formal institute disciplinary action. So, my lord, what has happened in this case? The institute violations which on that day occurred, there was first and foremostly, there was a complaint. The institute had taken a notice of it. There was an information received that such and such person has died. And thereafter, the institute looked into the material, found out that there was a major indiscipline on the part of the petitioner. The punishment which has been imposed upon them, let me reiterate this, my lord, it's for the indiscipline which is done. The consequence of the indiscipline is the death of the student. My learned senior was stressing upon the fact that there is no police and I am not responsible for the death of these people. It could have been something else on that day. It could have been that petitioner number 2 who was in completely drunken state would have died. Who knows that? Now, let me proceed with my submissions, my lord. My lord will keep in mind, these people are 4th year students, the final year students of the undergraduate program. institute has more than 5,000 students who are, and sometimes there are a lot of people who are at initial teenage comes, first year students. If the senior students behave in a manner in a residential institute, they tend to get affected by that. It cannot be said that the action of the senior student will not have any impact on the junior students. If they think that it is okay that for the underage people to get drunk and party and do these things, they have to suffer the consequences for this. But I will also demonstrate that what action institute has taken, how institute has proceeded with the matter. The penalty which has been given to them was not the maximum penalty. With all seriousness and respect, I submit this. Now let me show the statement first. That how the statement has been recorded, what statements, what they have stated in the statements, whether there was any admission of facts. So my lord will peruse the original record. Only one. Let me start from petitioner number 2, my lord, and I'll then read through the statements of petitioner number. Now, this all are happening on the context, my lord, that my learned senior has shown that on 4/1/2024, there was a note email sent to them. If my lord will take up my affidavit, I have given a blow-by-blow incident report. Yes. I'm sorry. Sorry, man. It is in the IA. I'm sorry. It's now in the IA affidavit in IA, my lord. I will just keep it in handy so that we'll have some amount of is page 69, my lord. Affidavit in IA. Page 69. It starts para number 5. To find out the statement, what is it? Find it out. Argument is written and my lord has got it. Yeah, let me now start. Now, my lord will see, my lord will turn to, I will go through this one by one, but let me just turn to page number 70 for him. Page number 70, next page, my lord. Now, this is an admitted position. And in the entry number 7, my lord will see for the moment. Student disciplinary committee meeting was scheduled to be held on 5/1/2024 to investigate the sequence of events that led to the unfortunate death of Pulori Aishwarya on 1/4/2024 outside the campus, and accordingly the petitioners were sent an email on 4/1/2024. This email, my lord, is a part of the writ petition. So writ petition, my lord, if page number 35, if I understand, my lord, 35 of the writ petition has been looked into. Then my lord will find this email. So before starting the proceedings, they have been given an intimation that such and such incident, you come, and they were aware what was the incident. Incident had happened on 1/4. 1/1 incident had happened. This individual has died. So on 4/1, this email was sent, page number 35, my lord. So it reads, as directed by the competent authority, you are hereby asked to appear before the student disciplinary committee at 5:30 p.m. on 5/1/2024 tomorrow in the student affairs conference room. Please note the student affairs office to attend disciplinary meeting at 5:30 p.m. and January 5th. So the intimation was given. Then they attend. Now, once they attend, this is the written statement. Their statements were recorded. This is what they have voluntarily submitted before the committee. My lord will take up the first. My lord may take up Jatuhu Vamsi's statement.
Where is that?
My lord, that is in the original record which we have given, my lord. or my lord can any of the one, my lord. What my lord has got is Jatu Vamsi, my lord will see IITG, his incident happened on 31st night. That is petitioner number 2, my lord, J. Vamsi. Jatuhu Vamsi. Yeah, my lord has got.
Yeah.
Yeah. I am Jatuhu Vamsi from BTech 4th year, Triple E branch such and such. On I went to my dad's brother's house. So they are describing what has happened. Dad's brother's house to my dad's brother's house to catch my flight. That is on 31st December 2023. So on the morning of 31st December, I woke up. I woke up around 6 a.m. He starts describing the incident from the beginning. He was been asked to describe it. So thereafter he writes, I have reached the airport on 7 a.m. After some time, I have called Srinivas. I asked, where are you? After some time, I have met Srinivas in the airport. We have checked in, and me and Srinivas went to Deepika and Ashwarya. After that, Srinivas said that he is hungry and he goes on. He says that he reached Guwahati at 12 p.m. My lord has got the last line of the year. Thereafter, he has taken. Now, my lord will turn to the next page. He describes what has happened from 1:30 p.m. till 5:30 p.m. And the last 4 lines of the paragraph, sir, my lord can look into it. We are in the cab. From it starts. We are in the cab at 5:30 p.m. Then we went to Kapili Hostel Junction to join Ashwarya and Deepika. As the cab driver refused to go to Disang Hostel, after 2-3 minutes, Ashwarya and Deepika joined me and Srinivas in the cab. Then security guard did not stop us at the main gate. Then we went. So this, let me pause here for a moment, my lord. My lord will note that he does not say in his statement that they wanted to get down. It is not his versions. The versions keep on modifying and keep on become incrementally better as the replies have been submitted. My lord will notice that. Then he says that he went to Rudraksh Mall at 6 p.m. My lord has said, sin. So my lord, thereafter 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. He entry at 7:30 p.m. at that particular pub. My lord has got in between. Thereafter, after some time, we went to the pub and asked for the security guard regarding the pub timings. My lord has got that line? Yes. After that, he said 7:30. We waited on 4th floor, and sometime in the after some time, the time is 7:30 p.m. I asked him to allow us in the pub, but he did not. Then he goes on. My lord, online passes are there in the last line. My lord will turn to the next page. After that, we all of 4, we saw the whole pub. My lord has seen that line. And we checked out the best place to sit. He says he checked out the best place to sit and found a 4-seater table, and we sat over there. After 5-10 minutes, waiter asked that what we have to take. Then me and Srinivas ordered one Shivas Regal 30 ml pack, and Deepika and Ashwarya ordered mocktails, non-alcoholic one. After some time, we have talked to each other regarding how the vacation went like. Thereafter, after that, myself and Srinivas went to the bar waiter and asked for the Valentine whiskey. Then we brought that Valentine whiskey and we have took that. After that, Ashwarya and Deepika ordered vodka along with the Sprite. Then we had discussion about the relationship of me. Then after we brought 4 tequila shots, whiskey, then vodka, then 4 tequila. Each of, not that I'm complaining, each of is for one person. We had that one. We drank all packs of Glenfiddich whiskey. All 4. After that, we took 4 tequila shots. Each of one is for one of us. After some time, I asked Srinivas, can we book the hotel? My lord will mark that line and I'll pause. So it appears, my lord, that First there was in whiskey, then there was in again vodka, then whiskey, tequila. All three has been consumed in repeated manner and they were not drunk. Apparently the petitioners number 1 and 3 were not drunk after so much of consumption. I asked Srinivasan, can we book the cab, a hotel, to stay that night? I am bit sleepy and drowsy. He had admission there. After that, myself and Deepika talked to each other. That point, there was only 2 of us. After that, I can't hear, but I can able to see what is going on. Completely inebriated stage going on. When I come out of the lift, I vomited out. Then Srinivas look at book the cab initially to hotel, I suppose, but that line has not yet. But the cab driver refused something. Then he says, me and Ashwarya, Deepika sat behind the cab and the Srinivas sat beside the cab. Then we reached the hotel. I sat on the sofa at the reception and he goes on. He says, then we went to our room and then I slept. He does not remember what has happened after 12 p.m. And he says that the morning around 5:36 a.m., Srinivas came and asked us about the water bottle. Then Ashwarya showed him the bottle and Ashwarya bottle and the Srinivas left that room. And around 7:30, I have heard some voice. My lord will again mark this line. The time is here important. How the morning starts, he described the morning starts when around 5:30 Srinivas came. Who opens the door? He doesn't say. Why these facts are necessary here? Because I will at the end I will come, my lord. He had this gentleman was not so drunk. Probably he could have heard what was Deepika was going on. Sorry, that late Ashwarya was going on. What condition she was in? He says that around 7:30 p.m. I heard some voice and due to the urgency of the washroom, I woke up and I have noticed Ashwarya. She opened half eye and suffocating. Then I have called Srinivas. 7:30 incident, my lord. Not died on that time. She was alive, 7:30. Then I have called Srinivas and the problem according to him started at 7:30. Then I have asked Srinivas and after him or Srinivas and Deepika came to our room. After that, we got panicked and I have called ambulance. Then I have said Deepika to blow air through the Ashwarya's mouth, but she said she can't. Then Srinivas did that. I went down the bed. I have started rubbing Ashwarya's legs and assisted Deepika to rub Ashwarya's leg. I have also asked Srinivas to give CPR. Then he tried. We gave CPR 3-4 times. He pressed near the heart and then he said, I have heard a small sound. After that, ambulance driver called me and said that he had reached hotel. Then I have asked him to come to our room, but he refused to come. They call ambulance in the hotel. Ambulance driver says we do not. Had they been in the IIT campus on that time, had they would have returned to IIT on that time, on that day, this incident could not have happened. Ambulance would not have refused. There would have been some other person who would have heard Deepika's flight for life. Let me go forward. He said, I asked him to, he refused to come. After that, I went down and checked the ambulance, whether it had arrived or not. It was there and there were 3 people standing in front of me. He says, then I asked him to come along with me. Then I went to our room and there I have collapsed in front of service lift. So to my presumption, my lord, if he has collapsed on the morning itself also, he probably was not out of the intoxication which he was in last night. Then they say that Srinivas and Deepika and 3 members of the ambulance took Ashwarya to the ambulance. Srinivas said that the driver to bring jackets and something. I have took the jackets. Then he goes on that thereafter he eats puri sabji in the hotel. Then the incident proceeds without him. he is not there in the incident thereafter, my lord. Let me just also read through. I have take jackets and went to the reception. He refused to let me, he refused me to go to the hospital. After that, I asked the hotel manager to get some food. On the meantime, I have called my friend to bring charger. He calls his friend, doesn't call IIT members, anyone there. After that, I have ate puri sabji, and that time my friend arrived at the hotel. I took to the Polton Bazaar. Then I was took to Polton Bazaar. So after him finishing eating and everything, then he went to Polton Bazaar. It is not that police has come there directly. At least from his statement, it doesn't appear. Then I took the Polton Bazaar. I was took to the Polton Bazaar police station with the hotel manager. Then I explained all things. Sachin sir said to give letter regarding that. I went back to the hotel. I wrote the letter to the Polton Bazaar police station. Then some police officers come to the hotel, check the room, and we went to the police station. I have seen Deepika and Srinivas over there. So when he reached to the police station, Deepika and Srinivas was there. I was called for investigation. Then after that, I have asked to sit on the bench. After 2 hours, Srinivas called Srinivas called for investigation, and he thereafter describes what has happened to him in the police station, my lord. So I will not be troubling my lord with these details more. Let me just read the second statement now. Respondent number, petitioner number 3, my lord. Srinivas statement. Srinivas, petitioner number 3. Take out 1 minute so the meeting.
Yes.
Yes, my lord. Now, it starts similarly that 1/5/2024, my lord, regarding our friend's death outside the campus. He says, 3 minutes, you take it out. Then we together had lunch. Then the first line is this. I woke up at 4 p.m. is the second para in the first page, my lord. My lord has got that. Then I woke up around 4 p.m. Vamshi came to my room. Second,
Which one?
my lord is saying the Srinivas statement, my lord. It is little long. Srinivas statement.
Yes.
Statement of Srinivas regarding our friend's death outside the campus by the heading. Subject is this.
Yes, yes.
Myself, Srinivas. I started from my home. That I'm not reading because this is probably not connected to the incident immediately. Second paragraph, he says, at 4 p.m., Vamsi came to my room. That is petition number 2. Came to his room. Together they go to hostel and all that. Booking capes happen. Malad will turn to the next page. He says, so we went to the cab. It was better compared to the Vamsi. So they compare basically cab rates and find out that petitioner number 2's cab rates was better. They goes on and says, so we went to the cab I have booked. Vamsi sat in the front seat and rest of us 3 sat in the back seat. So Vamsi sits front, Deepika and Ashwarya sits in the back. Girls entered the cab at Kapili Hostel. When we reached the main gate, we thought of writing. Why don't you mark that line? They thought of writing at the exit entry, but security directly opened the gate and the cab driver not stopped the vehicle. And they would have asked the cab driver, the driver would have stopped. But the fact remains this, even though it was in their mind, they were conscious that they were supposed to do it. They have not done it. It is not the buswala example which the petitioner side is now trying to create. That is the reason I said, as the time progresses, my lord will see how the explanations have gone better and better. So I'm not sure whether this, under this CA, they thought of constituting a fact-finding committee. They say that they thought it is like a bus thing. And as the bus, while the IIT people, they go by the bus, they are not supposed to. It is also not correct, my lord. While you are trying to exit or entry from the IIT, my instruction is that everyone is supposed to make an entry because it's a residential hostel. This institute is responsible for the well-being of its students. We cannot shrug off our responsibility and say, no, we are not responsible. You do whatever you wish to. That cannot be said, and that argument cannot be made at this court, my lord. Let me now proceed. We thought of writing out and exit entry register. The security directly opened the gate and the cab driver did not stop the vehicle. We could have asked, not dot, whatever. Then we reached the Rudraksh Mall and Exoro pub. The Exoro pub, he says that Exoro pub booking was done prior. No details on that day for the prior booking was given to them, my lord, the committee. I will show. They only says, they did not give any details. Now my lord will come little down and my lord will come 1, 2, 3, 4, 5, 6, 7, 8 line. We had our first drink. Let us seen that. Fourth, 1, 2, 3,
Yes,
4, 5.
yes.
We had our first drink around 8:30 p.m. We and Bamsi had 3 packs of whiskey, 2 shots of vodka. Girls had 1 mocktail, absolute vodka, 2 shots of vodka. None of us something sorted on that day. Only me smoked sometime in Coca friends among something he says. Then next paragraph is very important. So consumption of alcohol is again admitted. The alcohol consumption has been probably the petitioner number 3, what petition number 2, what has been explained, has more details. And that is there on the record, my lord. Around 10 to 10:30, Vamsi said we will stay out. So the decision to stay out was, my lord, I'll pause here for a moment. Decision to stay out was initially between Vamsi and the petitioner number 3, that is Srinivas. Not these 2 girls, my lord, at 10:30. So 10:30, they remember, they understood that my position is not correct. Let me stay out. They were on that time, even though Vamsi was not feeling well, it has come out from the statement. But others were in there by their own admission, they were better. They were aware that after 10:30, they cannot, if they are supposed to stay outside the hostel, after 10:30, I will show that from the record again. You have to take permission. They could have called IIT professors on that time. IIT professors have helped people. I have made categorical statement that IIT professors have gone and picked up people from the police stations, sometime from the picnic spots, not been denied by them. They could have done that, not done. Srinivas, in his own admission, was better. Vamsi was not in a proper stage, probably. I am not feeling good. My stomach is upset. So we were discussing about it and we stopped drinking. At that time, myself, one over there was something over then was to stay till New Year celebration. So they sometimes therefore decided that they will stay till the New Year celebration. So I have discussed among ourselves and around between 11:30 and 11 and 11:30, we thought of me and Vamsi of staying so that he is asking, I am not feeling well and I may vomit. My lord has got that line. So 11:30, even though the discussion started probably at 10:30, they are certain because this gentleman is not feeling well. If the petitioner number 3 was in his proper conscious mind, he would have thought, let me go back to IIT. I do not have anyone here. These people are from outside. They're from Telangana, my lord. And there were incidents where IIT people have helped. But that is my presumption now. Probably he was also not in that proper stage of making decision for himself and Vamsi. Thus, they posed risks to the life of others. Let me continue now. I asking them, let me continue. We thought me or Vamsi of staying. So he asking, I am feeling not well and I may vomit. And sending the girls back to the campus. It was decided between petitioner number 2 and 3. Let us send the girls back to the campus. Had this been done at 11:30 also, they could have called. Somebody would have come and picked up. Why to wait till 12:30? Then it started. I started booking room and me and Vamsi accordingly booked 2 rooms, each for 1 person. My lord, I also stayed in the hotel. Sometimes stayed in hostels, my lord. Sometimes when we stay, two boys can book one room, my lord. But I do not know why they have booked 2 rooms here. Apparently, that explanation is this: there were some in the while booking, they could not realize that it was for 2 rooms they are booking. This 2-room business is also of some importance, my lord. Then after New Year celebration at 12 a.m., we thought of leaving the pub. 10:30, this man, 10:30, Vamsi started feeling unwell. Leave aside for a moment, let me presume against myself that probably that health of the late Aishwarya was not, probably she was well on that time. Vamsi was not well. Vamsi was continuously vomiting. He was saying I was unwell. As a team, they could have decided. My submission would be that probably Aishwarya was also unwell. They have not noticed it. Because when you consume so much of liquor, as per Vamsi's statement, and mixed it with vodka and with whatnot, tequila and whatnot, this will happen. Let me proceed further. 12, we thought of leaving the pub. We came between 12 m.m. and 12:30 a.m. When we are coming down from the pub, so pub coming down is 12:30 in the night. Pub in the lift, Vamsi again vomited. In the ground floor, after we came aside the lift, I cleaned up near a tap. Girls were waiting outside. Girls were not part of the discussion till then. I booked the cab to hotel as girls were in the plan of returning to campus. 12:30, they are still planning to return the campus. So we thought we can travel in the same cab till the hotel as it is on the way to the campus. While we are in the way, girls discussed among themselves that it is not safe to leave the campus, leave probably for campus it be at that time, because there may be any security reasons. So they said, we will stay in the hotel itself with you. So we reached hotel around 12:30. We went to check in. Now, my lord, thereafter 1, 2, 3 lines, 1, 2, 3, 4, 5 lines. The receptionist, it is room number 202. My lord has got. So 202, they check in. Then Vamsi slept on the bed. We separated the bed in 2 parts. So if he vomits, the bed will not get damaged. After that, me and Aishwarya Deepika talked for some time. I think around 11:30, Aishwarya went to sleep. She was probably using her mobile. That is the line I'm talking with us. Till that time, I woke up her and asked to move to another room. But she said, I have no problem to sleep here. You guys go to sleep in another room. That is petitioner number 3 and petitioner number 1. That is Srinivas and Deepika. Apparently, it has been shown that she has consented to stay in that room and these 2 people to go in another room. Now, that cannot speak for themselves, my lord. That cannot respond. She is no more. She cannot respond to what has happened. I said to Aishwarya to look at the room, to lock the room. Then we slept in another room. Around 5:30, I was thirsty. I went for water. I brought 3 bottles of water from the reception. At the time of checking, those were kept in Aishwarya's room. So I went for water. I knocked the room. Vamsi opened the door. Vamsi does not say who opened the door, my lord. My lord has seen. So his stories are being manufactured in such a manner that all faults are somehow can be avoided. Loopholes can be avoided, my lord. So what Vamsi does, Vamsi opens the door and went back to sleep. I asked Aishwarya, she showed where the bottle is by sleeping in the bed itself. Vamsi apparently, when opening the door, could not show him where is the bottle. When Vamsi was opening, I have not asked Vamsi also. My general reaction will be somebody when opening the door, I am asking to that person only, not to the person who is sleeping. So I'm not sure what was their mental condition on that time. I took the bottle and I went to the room in sleeping. I said Vamsi to lock the door. After that, around 7 p.m., my lord will mark that line now. 7 p.m., Vamsi called. As per Vamsi's statement, the call was made by him on 7:30 AM. So he's written it wrong. That is probably the intention was to write in AM only. He has written it PM, but intention would have been writing to AM only. So the call, in my understanding, as per Srinivas, the petitioner number 3, he made the call at 7 AM by the Vamsi. Vamsi called and made a phone call, said Aishwarya is doing something, please come. On that time, maybe, my lord, she was having breathing difficulty. To my understanding is because Vamsi was in inebriated stage, he could not realize that she would have been making that sound for some time. Not from 7, probably from 5, probably from 3. Nobody knows. Apparently, 3 bottles or water bottle were taken. All are kept in her room only, not in their room. So this gap manufacturing, my lord will see that 5:30 he says, no, Deepika was well. Deepika was, sorry, Aishwarya had shown me that bottle. These are all gap manufacturing, my lord. I'll proceed. Aishwarya doing something. Then me and Deepika came to his room. He was standing at the room door. I asked him, what happened? He said, Aishwarya is breathing heavily with eyes half opened. When we saw Aishwarya like how a normal person sleeps, then we tried to wake her up, but there was no normal and no movement in her body. I said Vamsi to call ambulance. I did CPR and on her chest. Between these, I went to reception to call someone to check upon Aishwarya. What happened? All of 3 are in tension and shock. He tried to get help, no doubt, my lord. This help they could not get it because they were staying in a place where the situations were not trained professionals were there. IIT has an hospital inside. If such situation would have happened, immediately CPR giving people or emergency service could have been called. This life could have been saved. Let me proceed further. I said to Deepika to blow air to Aishwarya's mouth, but she said, I don't know how to do it. Both petitioner number 3 and 2 says Deepika does not blow air to the Aishwarya's mouth. Then I did it. 10-15 minutes later, ambulance arrived. This probably was golden moment. The driver said to bring Aishwarya down. Ambulance did not agree to go above. Said you bring it down. Staying in IIT, not would have happened. But we were unable to carry her. I sent Vamsi to call them and bring stretcher. When we tried to carry her, we shifted her to another bed. When ambulance driver came, we carried Aishwarya down near ambulance on stretcher. We seated in the ambulance. I called her father from her phone. I asked, did Aishwarya have any breathing on heart problem? Or probably her father got tensed. Her sister took the phone and actually she is a medical student. She asked what happened, said she is having breathing problem. Before she went to into something probably seizing, Aishwarya's sister said, don't panic, nothing will happen. Put oxygen masks, do ECG, shock treatment, CPR. These people who are not trained, my lord, to handle such kind of situation. Had they would not have been drunk so much on that day, on the fateful night, they would have made a decision to come back to IIT at 10:30 itself. Did not do it. Thus, it has resulted into an health and safety issue for an late Ashwarya. She will be fine. We reach hospital and doctor started checking Ashwarya. Her sister was on call. The ECG was flatline. So when the doctor put the ECG, she was no more. Probably when the last breath would have come out in the hotel itself. They did not realize it. All that I can probably, this is all ruse. I was unable to convey it to her sister. Then doctor said she is no more with her sister when I give him the call to the doctor. Then I informed our friends, not to IIT. I said Deepika to inform administrator. Deepika said what Deepika will respond, my lord will see. About this thing, because I was talking to her parents. After some time, Ashwarya's uncle came and we shifted Ashwarya's body to mortuary. By the time Piyush, VP and Govind, HAB reached the hospital, so IIT people also reached the hospital. There was no slackness from IIT. They reached as soon as they came. Reached the hospital, we came to Polton Bazaar police station. Vamsi also says that when he reached Polton Bazaar police station, after consuming food and all, he was there. Deepika and petitioner number 3 was there. I am having FIR with Deepika since 1 year. I have submitted 3 documents, namely anti-ragging, code of conduct, pledge, and hotel and hostel undertaking. Last he says, so my lord will see the undertaking. Now I'll show my lord the undertaking after the reading of Deepika's statement. Those undertakings are absolutely clear that you cannot stay outside after 10 or 10:30. I feel guilty about the incident, Ashwarya's death. As she is our close friend, we are to be blamed for the cause. Clear admission. Now let me read the statement of the petitioner number 1. Petitioner number 1 statement starts with the incident on 31st December, 1st January. My lord has got that. Sorry? No. Tata, you have taken 15 minutes. Let us think of my next 15 minutes. On 31st December at 6:45 AM, my lord has seen. My lord will not look into this because this is again EA. We, Srinivas, my lord, in 1, 2, 3, 4, 5, 6, 7, 8 line. Hostel is the last word, Nisang hostel. Then my lord will see Srinivas, Srinivas, my lord in the bracket. My lord has got that. Second word. Srinivas booked a cab and started to city at around 5:45 and 6 PM. We went through the main gate. We stopped the cab, but security made us go. We did not enter details. Now, apparently, I'm literally my lord. Srinivas says the cab was not been stopped. Cab driver went. She says cab stopped, but somehow because the security opened, we left. Difference been created that as if we are sitting in the bus, so we are going, not required. So there is a contradictory versions coming on that time also. Reached Rudraksha Mall at 7 PM. My lord will thereafter, they says they have gone to Exora and all that. My lord will see 1, 2, 3, 4, 4th line, 8:30 PM. My lord is stated. See, 8:30 PM. First, me and Ashwarya ordered a cocktail. Boys ordered whiskey. My lord has got that line. We did not like the taste of cocktail, so we ordered vodka, which is diluted with Sprite, and boys had one more round of whiskey. Then we all were talking and playing some games, dancing. Around 10 PM, we all had a round of tequila shots. Around 10:45, Vamsi said he is feeling uncomfortable or unwell. So, my lord, from Vamsi's statement, the timing is 10:30 to 10:45. The range of timing which comes around, my lord, is 10 to 10:45. That time, Vamsi, that is petitioner number 3, was unwell. Admit it is their case that purportedly they were fine. But it is incomprehensible when these two people were underaged, that is Deepika and the Vamsi, why they indulged into so much drinking and why they did not go back to a hostel in safety. Let me read forward. Boys were discussing to stay back in the city. So discussion was not to keep the girls there. Me and Aishwarya decided to come back to the college. They booked, cinemas booked 2 rooms for each person. Something has happened by default. As a matter of fact, generally when 2 boys are staying, my lord will know, 1 room is generally booked. But probably, I don't want to guess, but probably the influence of alcohol would have been so much, they did not realize how many rooms they are booking, or they would have clicked more. And also, boys made the payment, room at 11:30. We wished each other at 12 AM and came out. I had to call my parents and wish them. We booked the cab to the hotel and me and Aishwarya thought of taking another cab. My lord, they were thinking to come back to the hostel. They were thinking to go back. But somehow they have now decided to stay there. Book as it is on the way to the college. In the meantime, Aishwarya said maybe it would be safe if we stayed back than going to the girls, going along 2 girls. All blames again shifted to Aishwarya. Sorry. Yes, she is no more. She cannot respond. She asked 2-3 times. So I thought the same and we checked in the hotel place. Now let me pause here for a moment, my lord. As per the statement of Srinivas, the decision to stay in the hotel was taken in the cab. As per her statement, it was not taken in the cab. We checked the hotel such and such City Palace at 12:30. After going to the room, Vamsi slept and we 3 started talking. For some time at 1:30, Aishwarya was sleepy and she was already laid on the bed. I asked her to go to another room along with me so that I can sleep, so that 2 can sleep together. She said it is okay. I will stay here. She cannot defend this statement. You guys go and sleep. I am tired. So I went and slept in another room along with Srinivas. Vamsi and Aishwarya slept in the same room. Srinivas said that he went to Vamsi's room at 5:30 to 6 AM to get some water. And Aishwarya showed where the bottle over her head. At 7:20 AM, my lord, again, see the timing changes. 7:30, 7:20. Vamsi called Srinivas and said Aishwarya is breathing heavily. She is doing breathing differently. Come fast. We immediately went to the room and saw her breathing heavily. And then she was calm. I tried to wake her. Probably when she was calm, wake her up by tapping. She did not respond. We immediately called an ambulance, informed the hotel management, and asked if they have the doctor's number. In the meantime, I tried doing CPR and blow air in her mouth. I heard some sound of air coming out from the mouth. 15-20 minutes later, so 7:30, 15-20 minutes later, so close to 8 probably, ambulance came and we took her to GMCH. While we were taking her to hospital, we informed her parents about the condition, not intimated IIT on that time. They intimated the parents. They could have intimated IIT on that time. Also asked them about the past health issues as her sister is medical student. We spoke with the doctor. Doctor has checked her pulse, taken ECG. After 15 minutes, doctor said she is no more. Immediately asked our friend for warden's ma'am number and caretaker. So once Deepika was no more, she asked for her number, caretaker's ma'am number, and informed caretaker ma'am. Did not take the call at 12:10 on 1st January 2024. I feel guilty about this. I have violated the rules that I need to inform the authorities if I decide not to come back to the institute after 10:45. Clear admission on that day. On 5/1/2024, she admits of committing violation. My lord is aware the rule of principal justice does not function in isolation. There has to be prejudice caused to them. There has to be prejudice caused to them of non-supplying of a document. If there is an admission on their part, on her part, that she has violated, where is the prejudice? I ask myself this question. I will demonstrate if there was no prejudice. This all thing has been admitted by them. It is admitted position that security entry log was not made by them. It is an admitted position that they did not come back after 10:45. It is an admitted position that Vamsi was unwell at 10 to 10:45. They decide not to stay. They decide to stay back. These three people were apparently in a better stage of mind, but they decided not to come back. At 7 p.m. when they have heard, they could have intimated IIT. Whatever, we do not know what has happened. But because of this violations of code of conduct, because of this non-maintenance of discipline, ultimate result has happened as a death, my lord. My lord cannot lose this fact. This indiscipline cannot be viewed in isolation. If this court allows such indisciplines to continue, we do not know where IIT will go, my lord. Let me proceed further, my lord.
How long are you going to take?
Lord, I'll take some time too, because then I have to show the allegation is this, that in the minutes, nothing has been discussed. I will show from the record, the minutes, everything has been
That's
discussed.
fine. You can take your own time,
My
but
lord.
today, it's just about 45 minutes left.
My lord, probably I will take more time.
There are other cases.
My lord.
So we'll hear it some other day again.
My lord, please.
Because he can't complete today.
Yes, the way, yes, records are placed.
Because the allegation is this, my lord, that there is no evidence. That the decision has been arrived without any evidence. That is the allegation.
Oh, fine.
I will demonstrate. my
No,
lord.
I'm grateful to my friend that he has produced the records, my lord. It's very good, my lord. But the thing is that, my lord, Lordship is aware there is some urgency in the matter. Tomorrow, my lord will take up.
I know.
Yes, my lord. Tomorrow, my lord will take up.
Probably I'm just intimating, I'm not opposing his prayer. Probably my lord had indicated yesterday that my lord had some difficulty tomorrow. I do not know, but my lord had.
Tomorrow day after, I may be going out of station.
I'll just try our luck, my lord.
No, tomorrow I'll be there.
Yes, my lord. Perhaps my friend will be able to complete tomorrow, my lord.
You can complete tomorrow,
My lord, I'll try to finish it up.
Yes, my lord.
but your judgment may not come this week.
Sorry, my lord.
Your judgment may not come this week.
My judgment.
Your judgment.
Yes. No, that I am with your lordship, my lord. For that, I am with your lordship.
Some problem is there, so I have to be out of station
Yes, my lord.
after Friday.
That is the fortune, my lord. I cannot change the fortune, but at least my friend will complete, my lord. If I have to say something, I don't think so. I don't think so. The way my friend has produced the records, I am required to say anything, my lord. But even then, my lord, tomorrow, my lord, after the motions.
I have only got 1 hour to my lord. Yes,
No, I'm not stopping you.
No.
I'm not stopping. It's just that because there are some
Yes, my
other
lord.
matters.
Definitely, my lord.
Yes.
So it may.
My lord will keep the records with my lord.
Yeah, you can keep it. You can take it back.
Okay, my lord.
But HB does any council of petition. Also heard Mr. ABD, Leonard Council for the respondents, 3 to 7. Correct?
My lord.
It's 3 to 7. But least for further hearing. On tomorrow is what, 18?
Tomorrow is my lord, 2018.
18. Huh? My lord, we'll make a mention in the morning hours after the motion matters. Highly obliged. my lord.
Yes, you can keep it. Tomorrow is hearing day. no?
Yeah, my lord, there is a divisional bench as per cause list. Divisional bench is there of my lord as per the cause list. I think I have seen the cause list.
Yes.
Can it be? if my lord-
Two more, please.
No, I'm not saying, I'm just
Kindly.
intimating the court that there was as a
It's
clause.
it's for the.
Obviously, I'm just telling the court there was a.
Kindly.
We'll see, let it
Yes,
come up tomorrow.
My lord.
You know, there is one item, my lord, item 19, maybe taken up some other day, my lord. I think it is to be called when next.
Okay, on request made by HK Das and the counsel for the petition. When do you want?
After 2 weeks. my lord.
Is the matter of the 2 weeks.
Highly. appreciated.
Sixty of supplementary list, motion.
May I please, your lordship. Lordship, on the last occasion, you have told us to file an additional affidavit.
Where's your additional affidavit? When was the order passed, judgment?
5/4, your lordship, 5/4/24.
Okay, heard MS,
G Jain.
G. Jain Leonard counsel for petition. Petition on this. Petitioner to take steps for service of notice on all the respondents by registered post AD within 1 week from list of the 6 weeks.
61.
Same order.
Eighteen of Delhi list, stay vacating application.
Stay vacation application. It is covered. It is admittedly covered.
Malad on 16/5/2014, Malad, it's Malad, the matter has been fixed for admission hearing. Wrongly, it has been listed on the stay vacating column. Malad.
Doesn't,
The
1 minute. Which date?
16/5/2014, Malad.
In the IA.
In the IA, Malad.
16/5.
16/5. 2024. Wrongly, it has been listed.
So the hearing has to take place.
I don't know. Otherwise, if I may just show a few pages, I think this issue is already covered.
No, but then there's already an order saying that the hearing of the main writ petition will take place.
Because when the IA, we have filed an IA, he has been enjoying the stay in a covered matter from a long time. And I filed an IA for vacation of the stay. And this honorable court said, we'll take up both the IA and the writ together and we'll decide everything. And that is because otherwise issue is extremely small, my lord. There's nothing in this issue. And pendency of this interim order, he is not going to benefit anything out of this interim order. He is claiming, my lord, basically provincialization of his services. Now, this post is a post of a tutor. As per the, my lord, act, this post is a personal post, meaning thereby, when the petitioner dies, when the person dies, the post also dies. So, continuation of the interim order, he is not going to benefit anything, my lord. And all these matters, my lord, various coordinate benches of this honorable court, I'll show, in fact, my lord's order is also there, I have annexed. all these matters have been relegated to under section 14 before the appellate authority. It is as simple as that. Now, he wants to bring all these technicalities so that he can keep continuing the interim order.
No.
Which he will not benefit anything. By blocking my provincialization, he is not going to benefit anything out of it.
Okay. We'll list it on Tuesday, the hearing.
My lord, my lord.
hearing,
My lord.
List
Tuesday.
this matter for admission hearing on 23rd.
Malo, can it be on Thursday, Malo? Thursday. On
If
page.
he wishes on 25th, I have, but both the issues need to be decided because there is nothing in this matter. And even the interim order which he is enjoying, it doesn't help him in any way. Obliging.
2021.
I would urge upon your lordship to take up item 21 first.
21.
Lordship. Lordship, it relates to an selection process for filling up the post of regular principal of National HS School, Lordship. It was initiated on 21/6/2016 and Lordship, I have been told, Lordship, all those candidates who appeared in the selection process along with me have retired, Lordship. And there's an interim order in this case, Lordship. Will kindly peruse order dated 21/6/2019 once.
21.
21/6/2019.
Yes.
Lordship, at internal page 3,
1 minute.
there is an interim order in last paragraph.
Yes. Yes.
Lordship, at the last paragraph, in the interim, the respondent number 5, School Selection Committee of National Higher Secondary School, Namding, shall keep the records of selection for the post of regular principal of the said HS school to be held on 23/6/2019 in seal cover, and the said selection shall be subject to outcome of this writ petition. Lordship, since the other candidates who appeared had already retired, Lordship will direct the authorities to complete the selection, Lordship. By the school selection committee may forward the results of the candidates to the state selection board, Lordship, and subsequently the government.
My lord, I am appearing for the respondent number 5, school selection committee. Now, my lord, here some development is there. Because the earlier who was the member secretary, he has already retired. Now new person has been elected. So I may be allowed to contact him and to know what is the present position.
On last 3 occasions, he took time for that.
I could not get the instruction, though I was directed, but I could not collect the instruction. So I may be given some time to let me collect the information.
Heard Mr.
MP Sharma.
MP Sharma, Learned Counsel for the petition. Mr.
D. Nandi.
D. Nandi, Learned Counsel, appearing for the respondent number 2,
Respondent
number 5, Oblique Selection Committee.
For the selection.
Submits that the member secretary, that the earlier member secretary had retired and a new member secretary has been appointed,
Yes.
correct?
Yeah.
He therefore prays for some time to enable him to receive instructions. Stop. Praise a lot. When do you want?
I don't, in the month of August. first
Why,
week,
why August? Why are we going so far?
Because I am to get the.
Where's your,
He is in Lamding, man.
Maybe, Lordship, but he got enough time, Lordship.
yes. After 2 weeks, I'll give you.
Lordship may kindly fix a date.
2nd August.
Stabilize that. So deep clearance.
Mr. Ayalam, council appears for the NCT. NCT.
Alright, I am appearing item number 20, madam, for resolution number 5. They are not proceeding for copy, I think. Not sure.
24.
Wait, please, Your Lordship. On the last location, they are directed to get the instruction as regards the payments of the area salary. There is a direction, Your Lordship, already issued by the commissioner that we should be paid. But in spite of that, we have not been paid. It will be tomorrow instruction. Oh.
Yes, what is this?
Lordship. Lordship, last chance may be given, your lordship, because they are delaying, lordship, I agree that they are delaying the matter because they, earlier they were in ME schools, later it was amalgamated. So now, they are getting all the detail from
Your
the.
Lordship, that's a long story. In fact, that submission was made
No,
on,
I've sent this letter.
yes, I was not given a copy, Your Lordship.
No, but
Hmm.
here practically they're trying to delay the matter.
Lordship.
Yes, Your Lordship.
So I'm giving them a last chance.
Last chance, your
And then we'll pass appropriate orders.
Your Lordship, that may be observed in the order itself.
Sar Sinha, Leonard Council. MSD Mushari, Leonard Standing Council Secretary Education Department. Is allowed
Lordship, 2 weeks.
2 weeks time as last chance to receive instructions. But if no instructions are forthcoming by the next returnable date, this court shall pass appropriate orders on the basis of materials available on the court. Mr. MP Sharma and council appears for the respond number 4.
Pleasure.
Deeply obliged, Your Lordship.
Try to get something with
Your Lordship is fixing a date, Your Lordship, or it's after 2 weeks?
2 weeks. Do something.
25, 26 and 27.
Yes, TV, what is
Yes,
this?
my lord, lordship kindly peruse the last order 22/11/2023. In this case, my lord, 22/11/2023. Earlier also, the lots of order has been passed by this honorable court, my lord, to obtain instruction whether they have been giving the opportunity to provincialize the services of the petitioners, because similarly situated person have already been regularized, my lord, with the approval of the government decision, my lord, in the district of BTC, my lord. But Nayak Padma is not available, my lord.
My senior is on legs.
Who?
Who's your senior?
Mr. P. Nayak.
Oh, P. Nayak is the standing council BTC.
Yes, Lordship.
Yes. So what do you want?
Lordship, we have communicated to the department, and Lordship, it is at its final stage of consideration. Some more time may be granted.
My lord, in this case, what happened, my lord? They have filed affidavit and they have admitted that remaining 90 gate 4 and gate 3 are left out. Even then, they have always taking time, my lord.
Yes.
And there were
No,
several
what
orders.
is your submission? What is your instruction?
Lordship, we kindly may grant us 2 more weeks, Lordship.
No, for what?
Lordship, as per my senior's instruction, Lordship, their it is at its last stage of consideration. So the lordship, their prayer is being considered. for
Lordship,
regularization.
can you record the her statement, ma'am?
Third MSK Devi Learned Council petitions. So, MS H. Barrow, Learned Council, appearing on behalf of Mr. P. Nayak, Learned Standing Council BTC, on instructions from her senior, submits that the cases of the petitioners are at the last stage of consideration. And therefore, prays for another 2 weeks time.
2 weeks time.
2 or 3.
3 weeks.
Well, 2 weeks there is given
Prays for
because
3
there are.
weeks time.
Oh, yes. ma'am.
Regular
You
basis.
can, kiman tarik ho, sir?
Praise the Lord.
Give a
Please.
date, my lord, otherwise the case will not come up. On, my lord, July 25th. Kiman delay?
July. July 25th will be 3 weeks.
No. August, my lord. First week of August, my lord, 2nd August. Ekon hoyni next day. Or 1st August, my lord, it says Thursday.
12th August.
12th August. Khali oblige.
Wait, last year.
28.
This is regarding the promotion from grade 4 to grade 3. On last occasion, you also kindly peruse the order dated 14/6/2024. This is important. On last occasion, your lordships, 14/6 order. May I read the order, your lordship? The AR Terwilder Ladakh Standing Council Higher Education Department has placed on record the communication issued by the DHE, wherein the director has undertaken to reconsider the proposal submitted in respect of the petitioner for his promotion to the post of library assistant from the laboratory bearer educations against the vacant post of one Bipin Chandra Burman, who was promoted.
Gogoi.
Lordship, we have,
Where's the order?
Lordship, we have received the proposal, latest proposal from the principal on 25.
What is the order of promotion?
Lordship, that is the issue.
That is the 25/6, it is now the consideration, it will be done, Lordship. I have received that instruction today, I have received that instruction, Lordship.
What is the instruction?
The court has specifically stated that on next date, the education shall produce the order issued regarding the promotion.
Una pieza last time, sir. Una pieza, no? To communicate position or it was a communicate position. How will it go?
Now, more than 1 month, nothing has been happened.
It's a thing of public business. Okay. Lordship, it's a order of 14/6, Lordship. Otherwise, policy has sent on 25/6, Lordship. So Lordship may give some time, Lordship, we'll do, Lordship.
And they are praying for weeks time.
Lordship, we'll do.
I think that is fair enough.
We'll do. Even Lordship, the proposal was issued on 25/6. Order, honorable court order is 14/6.
Mr.
H. Burra.
H. Barrow and the concept petition. Mr. Gay Gogoi, no, Standing Council, Higher Education Department, submits on instructions that the fresh proposal for upgradation of the promotion of the petitioner to the post of library assistant has been received from the principal, Kamruk College on 25/6/2024 by the Directorate of Higher Education Assam. Stop. He also submits that the case of the petitioner is under process for consideration and therefore prays for 1 week time.
10 days time,
and we prays for 2 weeks time.
10 days time, maybe, Lordship.
Finalize the claim of petition. Praise the Lord. This is the matter. After 2 weeks.
Let me fix your lordships and an order.
My lord, may
order regarding promotion shall be.
This is the matter on 2nd of August.
2nd of
August.
And on that day, the DHE shall produce the order of this regarding promotion.
There's a process. There's a process.
And since there is a specific.
Put the hang them without hearing them.
Now, since this is an order passed by this honorable court,
There
shall
is-
produce.
there is-
That should be honored. That is how.
It is not a case that we have violated the honorable court's order.
No, this is the order. Last.
The proposal, the fresh proposal has come from the principal on 26 June.
One,
now-
one phone call will be clear regarding the order of the promotion. Lawsuits.
29.
Lordship, kindly pay the last order of this honorable court, Lordship. Lord, I retired in the year 2020 in the month of February. My lord, this amount, Lordship, has been kept pending only in the name of Lordship audit objection. That is in respect of only 64,000 rupees. And around Lordship 25 lakh rupees that is entitled to the petitioner. DCRG and the area salary, Lordship.
Secondary education?
Lordship. Lordship, we have received our instructions, your lordship.
Yes. Have you seen the order of 21/6/2024?
Lordship.
Last order. Last order of this.
Lordship, the instruction that we have received is that the audit authorities, they have raised objections, your lordship.
How have you dealt with the objection?
Yes, that is the question.
That is what this court wanted.
Lordship, that was required, but in this instruction, your lordship, that has not been answered, your lordship. That-
Then you get the instructions and
Lordship,
come
I
back.
read the instructions.
Similar instruction they are placing, Lordship, since month of January, Lordship, several occasions. Without taking any step for solution, they are just coming
Lordship,
with the
this
instruction that
instruction-
because of audit objection, amount is not releasing.
Lordship, next week, your lordship, I'll get an updated instruction.
Kurt M. Khan and Council. MSD Mushard, then the Standing Council.
Secondary
Secondary education. Place for 1 week's time. To enable him to receive instructions in terms of the order dated 21/6/2024. So it's allowed list on 25th.
Lordship.
Obliged.
31.
My pleasure. Lordship, my lord, matter relates to selection and appointment of a librarian, that is a college, my lord. Last occasion, my lord, Lordship, direction was given to the department to obtain instruction, my lord.
Yes, Lordship, last time received instruction, I just printed, Lordship. Otherwise, there is some complaint is there, Lordship. On the basis of complaint, Lordship, petitioners called before the office to attend the hearing, Lordship. She was not present, Lordship, he was not present. Otherwise, college authority also, Lordship, called for that purpose.
So what's taking you so long to file the affidavit?
Lordship, regarding affidavit, 24 matter, Lordship.
That's why,
Lordship,
since you've got to file an affidavit.
today I received, today, just now. Out of it, out of it.
You appear before before whom, deputy director?
Lordship.
No, this is to the president of the governing body, isn't it?
Other documents are also there, Lordship. That is the reason, Lordship. So we have called for the presidents of the governing body, Lordship, to appear before the So Lordship may fix the matter after 10 days. In the meantime, Lordship will do.
Heard, Mr.
K.I. Mazumdar.
K. Majumdar, learned counsel for the petition. Stop. Mr. K. Gogoi, learned standing counsel higher education. Submits. That the Directorate of Higher Education has received complaints against the principal and the president governing body of which college?
NC College.
NC College, Bodhapur, Lordship.
Of and of NC of the
Navin Chandra.
Navin Chandra College.
Yes, ma'am.
From Badharpur. Regarding accepting of bribes from selected candidates, non-selection of candidates who got highest marks, manipulation of Viva marks, etc. Accordingly, the Office of the Directorate of Higher Education fix the date, fix 12/6/2024 for a hearing by calling upon the president of the governing body, by calling upon the principal and the governing body, president of NC College. Stop. However, as the president of the governing body of NC College did not attend the meeting on that day, another date has been fixed on 23/7/2024. Stop. He therefore prays for some time to enable him to receive subsequent instructions. Praise the Lord. List after.
After 10 days, 2 weeks, Lordship.
Date may fix, my lord.
Yeah. Fifth August.
May I receive this copies, my lord? I have.
It's an internal communication, Lordship. It is not.
Internal communication.
Obliged.
32.
May I please, your Lordship? The matter pertains to promotional post, my lord, headmaster, my lord.
Sir, sometime may be required for filing.
Therefore,
And for the respondent number 6 filer.
how about the others?
That's it, the government now.
Elementary.
One of them may be required for filing affidavit in authority.
Okay, I'll give you one with that. Heard,
These are
Mr.
last sons, my lord.
Heard, Mr.
Ego high.
A. Gohan, Learned Council. Mr.
HP Gwala.
HP Gora, Learned Council appealing for the respond number 6 is allowed 1 week time to file counter affidavit. List number 1.
Date may be fixed, my lord.
33.
May I please, your lord? My lord, in this case, affidavit has been exchanged already over. And I have been replaced. I have challenged the order of transfer because I am also ad hoc. They have brought another ad hoc. So one ad hoc cannot be replaced by another ad hoc. This honorable court has stayed it. And that man has been taken back, reverted back to his original school. As per private respondent. That letter is there, my lord.
So it has become infractious.
My lord, he has been taken back by virtue of the court's order. I take you, lord.
As per court order, noted that.
Where's the order?
Page 27 of their affidavit, my lord. Kindly see.
Page 27 of
Their affidavit, my lord. In pursuance of the order of Honorable High Court, such and such, the kept abeyance and further order of Sri Ramchandra Saha, science teacher, is hereby directed to join his earlier school. He is attending that school now, my lord.
which affidavit?
Of their affidavit, my lord. That is page 27, my lord.
In the writ petition.
Yeah, not writ petition. Yes, my writ petition, they have filed an affidavit, my lord.
There's no affidavit.
Affidavit is there.
No, I have not.
This is your affidavit, Ram Saha.
This is IA for.
There is IA they have filed, my lord. In the IA, my lord, you will see.
IA not been disposed of.
Page 27. It has also been disposed of, my lord.
It's kept in abeyance only.
Yes.
It's not been reverted. So it is not infractious. Pursuant to this. So
No, wait, fix for hearing any day.
you want to fix it for hearing?
No. I leave it to lordship.
Okay, on request made by C. Biswas, the counsel for the petition. List the matter for admission hearing on
Yes.
after 2 weeks.
I've got no objection, any date, my lord.
After 2 weeks.
3 weeks, let it come to 3 weeks.
2 weeks.
But interim order is there, that should be continued.
Interim order passed ready to continue. till the-
No problem.
34, 35.
Both cases are regarding the non-payment of the retail benefit. Lordship kindly see take the order dated 21/6/2024. The several order has been passed to file the instruction or file an affidavit. But no affidavit has been filed.
Yes,
And then what they-
the instruction today, my lord. We'll file our affidavit within
You receive your instruction.
today, my lord. Today we have.
We are waiting, the retirement benefit has been first order lordship is given. That
Affidavit, my lord.
immediately it
So how long will you take?
2 weeks, my lord. Within 2 weeks, I'll file.
more time. If they get it within 1 week, they can file an affidavit. There's no problem.
Get it.
And lordship may fix the date. Otherwise, the matter.
But Mr. P.P. Barra.
Yeah.
Then counsel for petitioner, Mr. B. Kaushik, London Standing Counsel,
Elementary.
elementary education submit that he has received instructions and placed in 2 weeks time and to file counter affidavit. Grace a lot. List on 7th August.
Yes.
I am appearing for Respondent number.
Right. 31 is same.
It's
MS,
M. Burman on behalf of SK.
London Council appears on behalf of Mr. S. K. Methi, London Standing Council,
Accountant general.
Accountant General. Yeah.
35 also same.
35 is same.
Oh, 35, isn't it?
Yes,
It's not all of it.
Connected.
Thirty-seven.
May I please your lord. My lord, the matter is being examined by BTC authority, my lord. They have so 2 weeks time to take a final call, my lord.
Okay, heard, Mr.
J. Ahmad.
J.
Ahmad.
Ahmed, London Council for the petition. Mr. S. R. Rao, London Standing Council, BTC submits that the BTC authorities are examining the case with petitioner and press for 2 weeks time to enable him to receive instructions. Praise the Lord. Please
It's
come.
on my lord. That may be.
You want 2 weeks?
2 weeks, my lord.
That may be given.
Okay, 6th.
6 August. Hello.
38.
My lord, in this case, Lordship was pleased to give an interim protection in this form of that the portal shall be kept open till today. Now, my lord, the required permission has not been given. So what I am praying, my lord, let the provisional admission be permitted subject to outcome of this case for the present minute.
Admission to DO.
Provisional admission, my lord, subject to outcome of the case. Because there is no permission, my lord, it has not been given. But admission means, my lord, in class 11 and
11 only. 11.
not that I'll appear in any final examination.
Session 24 and 25.
Yes.
24 and 25.
Supposing it goes against you,
Then my
I'm
lord,
thinking about the fate of the students.
no, my lord, then we'll take the risk. My lord, it's nothing. It's a question of giving a permission only. Meanwhile, we are pursuing it.
95 about 2003.
And my
So
lord,
file
from,
an affidavit.
no,
In this case, we are not fighting any.
my lord, from 95 to 2003, 13, they have already permitted.
We also take care of the students, my lord. We also care of them. Only because of my lord, without any permission from schools are running. That's why council had decided to my lord stop it in the.
Or lordship may say it will not create any equity in favor of the petitioner, that lordships can observe.
But Mr. K. N. Chelsea, then senior counsel, assisted by Ms. K. Devi, then counsel. How much time you require?
To file affidavit, my lord, it will take some 2 weeks time.
2 weeks. You've got your instructions?
My lord, we have a small instruction, my lord, not a brief, my lord, no previous comment.
Are you filing your affidavit or not?
We will file affidavit, my lord.
How much time you require?
2 weeks time, my lord.
Mr. T.C. Pitya, Learned Standing Council, Assam Higher Secondary Education Council. Prays for 2 weeks time to file affidavit in opposition. Prayers allowed. Stop. The portal tower one is still open?
Portal is open. But in the absence of any permission, my lord, they are not admitting us. So provisional permission we are praying for, subject to outcome of the case.
Okay. In the meantime, it will be the higher
School, only 20 school.
School authorities, 20 school authorities.
Item number 38 to 42
42.
relates to 20 schools only.
No, let us go one by one.
Yes.
These are not.
I mean, 3224 of 24, my lord.
The,
Okay.
the school.
Yes.
Is-
School authorities may be permitted to.
The school authorities are directed to permit the petitioner school.
Yes.
Right,
Yes,
to give
to get a admission.
provisional admission.
Yes.
To the students.
Yes.
To class. or
11.
not to-
Yes, 11.
11.
Class 11. Stop. However, such admissions shall be subject to the outcome of.
And outcome of the case.
So far, our portal is concerned, my lord, till today, my lord, portal is open. As per order
You
of
want the
court.
portal to continue to open?
Continue.
My lord, it cannot be continued, my lord, because we will have to stop. it.
No, at least for another 15 days so that in the meantime,
Yes,
process is over.
within, up to 10 days.
Another
or-
2 weeks, another 2 weeks.
The 2 weeks, my lord, they will.
You said
apply.
2 weeks, no?
Another 2 weeks.
Uh,
They will apply
the-
and in the meantime, they will try to obtain. approval from the
Respondents
DS.
number 4 and 5 are also directed to open, to keep the portal within bracket, inverted comma, DARPA, in capital, open till
To first week of
2
August.
weeks, no? 2 weeks.
2
you want us-
First week of August, my lord.
End of this, over there.
Oh,
Till 31st of July.
Till 2nd of
Okay.
August 2024. List the matter on 2nd August.
Only the session, my lord, 2024 and 25.
Yes,
next
yes.
one.
For the session 24 and 25.
For the session 24 and 25.
And my lord, this order may not,
25.
this order may not be a precedent, my lord, some other school also there.
Already, I've already said.
Only
yes,
only
yes,
20.
yes, It shall be subject to the outcome of. it.
Deep level.
My lord, the other cases are similar, my lord. 20 schools are there. My lord, 39 to 42, similar, my lord. There are 20 schools, my lord. They have come separately, my lord. That's why we have filed separately case, my lord, file case, my lord. Similar order, my lord. He knows, my lord.
Same order,
Same order, up to 42.
up to 42.
Yes, my lord. 42. Highly obliged.
Obliged.
It will be separate orders, but make it the same. We just go to it.
64 of supplementary list. Admission. $64.
No, no, yes, one please. List after 2 weeks.
43 of daily list orders.
May I please, your lordship? The matter pertains to date come retirement gratuity for the service rendered by the deceased husband.
Why is it coming for orders?
My lord, already, my lord, rule has been issued, my lord, on, my lord, 2017.
There is a private party or notices not served.
No, already, my lord, complete, my lord.
Huh? All parties are represented.
Yes, my lord.
Huh?
Several occasions, the authority taking time for filing affidavit, my lord.
Yes.
It is, my lord, squarely covered case, my lord. My lord, squarely covered case already disposed, my lord.
Only directly to Mr. R. Mozumdar who is supposed to file an affidavit.
Hmm.
So, madam, can he sometime will be allowed to? I have to ask him. Madam. So, madam, maybe takes after 1 week.
Last more than 7 years, my lord. It's very heartening, my lord. It is covered case, my lord.
Yeah. But Madhunar is not there.
Stated that the affidavit is already ready, madam. So, madam, sometime will be allowed. After 1 week. Madam.
So many occasions, my lord. Last
You're Mr.
A Gohain.
But A. Gohan and the council. On request made on behalf of Mr. R. Majumdar, the standing council elementary education department. Yes, the matter after 1 week.
Hello, Metro, maybe come on hearing column, my lord.
Yes. it will be
Suppose, my lord, kindly see, my lord, order dated 22/3/2017.
Without the affidavit, there's no point listing it for hearing.
Admission will be better. Orders of.
22/3/17, my lord.
Let it come up in the order state, then
I am on behalf of respondent number 3 or 8. I am on behalf of respondent number 3
AG, Mr.
E. Bhattacharya.
E. Bhattacharya, the standing council appears for the accountant general.
My lord, short date may be fixed, my lord.
1 week, I said.
1 week.
44.
Same, my lord. Oh,
Same order. Accountant general, your good name?
R. Borola. R. Borola.
M. Boro.
R. Boro.
R. Boro. That one only you change, otherwise it will still work.
45.
Please, your lordship.
Yes, go.
See, it is almost in the last stage before the finance lordship.
You said you'll give the compliance report.
Lordship, compliance report, until and unless finance is given the lordship, then we cannot lordship. Finance is also here party lordship. It is before the finance lordship, even finance has called a meeting on 19 lordship. Commissioner, secretary, and as well as director was all forward.
Can you also have a copy?
Okay, I do it.
Only area part, otherwise they are getting lordship. Only area part lordship, they will, that part also they will get lordship.
Okay, heard MS.
M. Zomanpui.
Zomanpui, it's there in that order. Huh? Learned counsel for the petitioners. Mr. K. Gogoi, learned counsel appearing for the respondent submits that the case of the petitioner is under consideration in the finance within the PRU
Lordship.
department. And therefore, prays for
At least 2 weeks time lordship.
2 weeks time to enable him to receive instructions. Stop. Praise the Lord. List of the
Lordship, if there can be any particular date.
list on. Yeah, 2nd August.
Well, instead of second, the next week lordship. Lordship.
7th.
Lordship.
Obliged, your lordship.
46, 47.
Lordship, before starting, my lord, lordship, can you have a look the last order, my lord? Wherein the honorable court directed that, my lord, to convey meeting and to comply the order, my lord. That your lordship will see the order dated 21st June 24.
This one. This one.
Huh?
ওই কপি হয় না ওটা নেই ওটা নেই কিছু না আমাদের And today, my lord, we have received one affidavit, my lord.
What affidavit?
One affidavit filed by my
You
lord.
filed your affidavit?
My lord, on the last occasion, this honorable court directed to hold a meeting amongst the authorities concerned, including the university authorities. And on 5th of July, my lord, this month, that meeting was held to resolve the issue. And along with the minutes of that meeting, I have filed an affidavit to them.
But does not indicate, my lord, compliance of the order. Lordship
When
can,
did you file?
My lord, today itself.
Lordship can have a look my copy, my lord. It does not indicate that order has been complied with, my lord. I have marked with the yellow, my lord. They are like, still, my lord, they would comply.
This is a different one. I think. Huh?
This may be by the education department.
So 163. This.
Hi, sir. Education has come, my lord. What is that instruction? Copy আছে নাকি extra?
What happened here, look, that petitioner was appointed as per the earlier 2011 Act. Now, that in the writ petition, the honorable Sindha order was direction was given to the university, to the registered university to give her the benefit. Now, thereafter, what they have filed a review. And in the writ petition, also, we are never a party, director secondary was not a party. Now, review petition, also, they have included the director secondary as a party respondent and got an order that some deliberations will be made with the secondary and higher education department along with the registry and to give approval as per the section 44 of the 2013 Act. Now, the petitioner was appointed under 2011 Act and now Guwahati University, they sought the approval as per 2013 Act. So that cannot be given though. That is the instruction I have given though.
13 Act will not be applicable, my lord. Order is very much clear, my lord. As per the last direction, my lord, they need to appear in person, my lord.
No, that is if this, the, what you call,
If the meeting is not held,
not
then personal appearance made. Since the meeting was held on 5th of July, so that part of the order has been complied with.
Holding meeting will not serve the purpose of the direction.
Kindly peruse paragraph 2, Lordship. Paragraph 2, there is an indication that, Lordship, university authority can do paragraph 2, Lordship. That particular, my lord, that particular instruction.
This one,
paragraph 2, Lordship. It says that, Lordship, Guwahati University Act 2013, my lord, may got it, came into force from dated 30/5/2013 as petitioner was appointed before the commencement of the Guwahati University Amendment Act 2013. Therefore, the university may consider the compliance of the honorable court order as per the existing act during the appointment of the petitioner, Lordship. It is the outcome of the Lordship joint meeting. So, Lordship may give some time, university will act upon that.
yeah, what is your?
Ball is in the court of university, my
Have
lord.
you received this letter?
My lord, we have received that letter, my lord.
At least 2 weeks time. Lordship may give some time, they will act upon. That's because we have cleared it, Lordship, they can do Lordship as per own Lordship. And honorable court's direction is that if we fail to Lordship, held a joint meeting, and if we fail to take a decision, then honorable court consider otherwise.
Okay, heard Mr. Jaya Barboya, learned counsel for the petitioner. Mr. PG Fugan, learned counsel appearing for the respondent number. Is the content cases?
Yes, my lord.
I'm for 1 and 4, Lordship.
1 minute.
In item number 46, my lord, I am the lone respondent.
Next, 115.
And item number 47,
Appearing for the sole respondent. Public Register Guwahati University. In contempt case 163 of 2020. Submits that he has filed an affidavit incorporating the minutes of the meeting. Held on 5/7/2024.
I believe 6 or 6. Normal time.
Comprising of the Vice Chancellor Guwahati University, comma, Register Guwahati University, and the Secretary to the Government of Assam, Higher Education Department. Stop. Registry to verify and place the same on record. Para, Mr. K. Gogoi, learned counsel appearing on behalf of
I'm
the
for 1 and 4, Lordship.
1 and 4. In contempt case number,
Lordship, contempt case number, Lordship. 1.
Case number
597, Lordship.
597 of 2022
item 47.
as produced a communication dated 9/7/2024 written by the secretary to the Government of Assam Higher Education Department, and the contents of the letter are extracted here and below, page 8A. Stop. Para. Mr. PG Fukan, learned counsel appearing for the Guwahati University. Praise for how much time?
2 weeks.
2 weeks time.
My lord, date may be fixed.
To receive to receive up-to-date instructions in terms of the aforesaid letter dated 9/7/2024. Praise allowed. This the matter again on 7th August. Mr. SMT GST, learned counsel appears for respondent number 2, 5 and 6. In contempt case number 597 of
2020.
May I take back, my lord, the copy of that?
Take it.
48, 49.
Most of it.
This is a contempt petition, my lord. Well, kindly peruse the last order dated 19/4/2024, my lord. 19/4/2024.
Date.
My lord, 19/4/2024.
Yeah, where's Majumdar?
This contempt petition will last 4 years, my lord, is pending. And the order of this honorable court or dated, my lord, 26/4/2019. This petitioners will be going to be retained, some of the petitioner, my lord.
Where's Majumdar?
Lordship, if I may, Lordship, Lordship, I am appearing for the newly pleaded respondent number 10. Lordship, yes, Lordship here, if I may submit, Lordship, here I have received an instruction. Lordship, here we have just recently received a proposal from the finance, from the education department.
No, newly implemented respondent number
10, Lordship. He's the
Commissioner of Finance.
Lordship, he is the current commissioner and commissioner and secretary in the finance department, Lordship. So as
there's no respondent 10 here.
Yes, my lord.
Yes. Or did you file a amended cost title?
Yes.
Maybe, Lordship, yes.
Huh? Where?
In contempt petition number 376.
There's no amended court title. Have you filed an
Yes,
amendment?
I have filed, but I have already annexed in my petition also. Filed it.
Amended cost title.
Yes.
It was reflecting in the last order.
Oh, see, I'm going to you.
But I find no respondent number 10.
Mainly contempt petition. my lord.
Okay, Jayant Narlika.
Lordship, yes. Lordship. Yes. So Lordship, here we have just received that they have just sent the proposal from the education department. Lordship, it's under consideration. Lordship may grant me 2 weeks time. We will process it. Lordship, it's in the staff inspection. Our approval will be required. But Lordship,
Okay. Heard Mr.
R. Islam.
R. Islam, Learned Counsel for the petition. Mr. A. Chalia, Learned Counsel, applying for the respondent number 10, submits that the respondent number 10 has received the proposal from the
Department of School Education.
from the
Secondary
Department of
Sec-
School Education on
Secondary, Lordship, that date has not been mentioned. Lordship.
and the case is, and the case of the petitioner is under consideration.
Yes, Lordship.
He therefore prays for 2 weeks time
Lordship, yes.
to enable him to receive instruction. Praise the Lord.
But a date may be fixed, my lord. Otherwise, since last 4 years, the contempt petition is pending.
Lordship, we have.
Now they have said that they have
Yes,
received, but
7th
as per
August.
my knowledge,
7th
already.
August.
No, Lordship, let him, this kind of statement he is making, Lordship.
51.
Maybe. Yes, in this matter, appeal has been disposed of, and my lord, the director has send the matter to the government, my lord. So my lord,
Appeal dismissed.
Dismiss, dismiss. So my lord, some time is required, my lord.
What instructions you have?
Right now, I have no instruction. Actually, it was dealt by the N. Khatonier, my lord.
Okay, heard Mr. A.K. Azad, Learned Counsel for the petitioner. Mr. U. Sharma, Learned Counsel, appearing on behalf of Mr. N.G. Khatanier, Learned Counsel for the respondent. Prays for 2 weeks time
2 weeks time.
to enable him to receive instructions.
He actually told me that 4 weeks is required.
Prays for 3 weeks time to enable him.
That may be fixed, man.
Praise the Lord. Please. On 14th August.
52.
Me please, Your Lordship. My lord, this contempt petition for violation of the judgment and order dated 15/12/2022, my lord, whereby Lordship directed the, my lord, to regularize the petitioner, my lord, as a lecturer.
Yes, Furkan.
My lord, I have apprised the honorable division bench. This is the order.
That writ appeal has not been, my lord,
The
till now, unless
honorable
notice has
single
been
judge's
issued. my lord.
order has been challenged in the writ appeal. That writ appeal is pending, and on the last occasion, on 25th of June, my lord, I have apprised the division, honorable division bench about the pendency of this contempt petition, my lord, and about the interim stay, my lord. After hearing my side, my lord, my learned friend was also there, my lord. That order has been passed.
Sir,
My lord.
No,
Since, my
there's
lord,
no stay.
no stay, nothing, my lord, service
no
has not
stay,
been
but
done.
there is a sentence, my lord, last sentence, my lord.
What sentence?
Await return of first sentence, my lord, await return of notices in respect of respondent number 2, 4, and 5 for 3 more weeks. I have taken these steps, my lord, already.
Prayer for interim.
And prayer for interim relief will be considered after service of notice upon the aforesaid respondents. After hearing my side of the story, my lord. that,
Whatever it is, it says the prayer for interim will be considered.
That is why,
It
my
is
lord,
not that the court has assured you that there will be a stay order.
it has not been rejected as yet, my lord.
Neither rejected nor granted.
That is why, my lord,
That means
I
you
pray
have to
for
proceed.
some more time, my lord. I pray for some more time, my lord.
More than 1 year, my lord.
I'll give you 2 weeks.
My lord.
When was this order passed? 25/6.
My lord. mistakes have been taken twice, my lord. This is the technical aspects of the mistake.
Mr. A.K. Sharma, learned counsel for the petition. On request made by Mr. P.K. Khan, learned counsel for the sole respondent. List the matter after 2 weeks.
That may be fixed, madam.
List the matter on 2nd August.
My lord, it will be later, my lord, on 7th or 9th, my lord.
Why 7th or 9th?
My lord, on,
You
on
pursue,
8th,
you pursue your appeal before the division bench.
my lord, on 7th or 8th, my lord. Let it be better for me.
7, my lord.
Seventh.
Most of them.
53.
Kindly peruse the order dated 19/6, my lord. And this one of the director to receive instruction, my lord.
Lordship, here in this matter, your lordship, on 21st June 2024, we sought for the the particulars from the Deputy Inspector of School Test Board, and accordingly they have sent it on 8/7/2024, and we accordingly received it on 10th of this month. So your lordship may grant some time for processing and bringing it to conclusion.
Give me the.
No, no. Move forward to the review first. Hmm.
Okay, heard Mr. K. Patkari, learned counsel for petition. Mr. B. Deori, learned counsel for the response number 3. Submits that the pension papers in respect of the petitioner was resubmitted by the director, by the Deputy Inspector of Schools.
Yes, sir.
Yes, school. On 8/7/2024.
Which we received on 10th.
Which was received by the respondent number 3.
Yes.
No, by the respondent number 3.
Respondent number 3 on 10th of July 2024. He therefore prays for some time to enable the department, to enable the respondent number 3 to process the papers of the petitioner and bring the matter to its logical conclusion. Praise the Lord. How much time?
4 weeks.
That may be fixed, my lord. The
He
requirement.
therefore prays for 4 weeks time, huh? List the matter on 21st August.
54.
Sir, in this case, my lord, pursuant to order dated 21/6/24, my lord, instructions, my lord, sought for that standing council, my lord,
Why is it
Beetle
coming for orders?
because my lord, service already completed, my lord.
Service is complete.
Complete, my lord. Matter has to come admission then, my lord. All private respondents are noticed and also.
Have they entered appearance?
Yes.
Yeah.
Number 8.
Huh?
6 deemed to be served, my lord. And 7, 8, they have prepared.
You are appearing for?
8.
For 7 not.
7, 8. How about 9? 9 is complete?
Yes, not complete.
Huh?
6 also deemed to be served. Logima order, that is, my lord.
19/6/24.
How about 9?
9 or please. 9 or? Huh? 9 is, it is, name is there, my lord. In the cause list. Correspondent, they have filed Okalat number. K. Ahmed. Hmm? T. Ahmed.
Yes. Elementary.
No. A provincial election, second issue. Several round of litigation matter already filed petition matter because my lord earlier occasion her name has already considered by the authority as a first assistant teacher. But subsequently, my lord, they have rejected, my lord. That's why, my lord, honorable court observed to take instruction by my lord B. Talukdar, my lord. On 21/6.
So B. Talukdar is absent today, my lord, from personal difficulty, my lord. I'll get the instructions, my lord.
Okay. Third, Mr. H. Das, Learning Council for petition. Stop. Peruse the proceedings of the Lawazima Court dated 19/6/2024. The notice on response number 6 shall be deemed to be complete. Stop. Mr. A.K. Azad, Learned Council, appears for the response number 8. 8 and MS S. Das, Learned Council, appears on behalf of response number 7. Correct? Stop. On request made on behalf of Mr. B. Talukdar, Learned Standing Council, Elementary Education. How much time?
2 weeks,
10 days, my lord.
2 weeks
10
time is allowed to file counter affidavit. At least after 2 weeks in the admission column.
Deeply obliged.
Item 55, next case, my lord. The service is complete, it may be listed for admission, my lord. Any date, my lord? My learned friend says obtain instruction, my lord.
Your lordship, instruction received, your lordship. Scrutiny of the above area proposal was made at this directorate, your lordship.
Petitioner is a teacher, she is praying for her area salary from 2017 to 2022, my lord.
And some discrepancy has been detected, your lordship. Accordingly, a letter was issued to the inspector of school, SDC Sipsagar. Your lordship, director shall process the above areas proposal immediately after meeting up on the same at the earliest, your lordship. I would like to place this instruction.
Third, Mr.
P. Hazarika.
P. Hazarika, Learned Council. Peruse the proceedings of the Lawazima Court dated 7/6/2024. Stop. Notice on the response number 7 shall be deemed to be complete. Stop. MS Didas, Learned Standing Council,
Second read.
Secondary Division. Department submits on instructions that the Directorate of Secondary Education received a proposal from the Inspector of Schools, STC, Sivasagar, dated 11/11/2022, regarding a release of error salary for an amount of rupees 15,05,370
My lord.
in respect of the petition. Stop. However, during the scrutiny of the error proposal, some discrepancies were detected, and accordingly, by a letter dated 25/2024, the 25 was what, and accordingly, and letter, no? What is it? To the inspector, what, there's nothing here.
Your Lordship, one meeting will be taken place, Your Lordship, discussing the discrepancy, how much money needed to be, Your Lordship submitted, Your Lordship. So Your Lordship, as per the meeting discussion will be over, Your Lordship, the proposal will be released.
It has been sent back again? No.
No,
No, here it says, some discrepancies were detected
Yes,
and
Your Lordship.
accordingly letter was written on 25/4/2024.
Yes.
So nothing is here.
What I haven't understood, my lord, some discrepancy they raised, my lord. It was revert to the inspector of schools, my lord.
No, it's not that.
Your Lordship, discrepancy has been taken place while taking the verification of the area
No,
salary
that's-
amount,
that-
Your
that
Lordship. Your
that
Lordship,
is clear in the-
regarding that, Your Lordship, one meeting will be taken up, Your Lordship, to clarify the discrepancies that has been made,
Okay,
Your
then,
Lordship.
that's,
So after that meeting, Your
what
Lordship,
did I say from the beginning? No, and accordingly, a meeting has been convened.
Yes, Your Lordship.
Convened
will be conduct
to rectify the said discrepancies
discrepancy.
in the presence of the inspector of schools,
Yes.
STC, Sipsagar. She therefore prays for
4 weeks time.
The
4 weeks time, Your Lordship,
It-
because that meeting.
4 years salary, my lord, 2017 to
3 weeks
2022.
time.
3 weeks, isn't it?
Prays for 3 weeks time. To enable her to receive instructions.
My lord, lordship may fix a date, my lord, after 3 weeks, any date, my lord.
14th August,
No, it may be come up for admission, my lord.
in the admission call.
My lord, oblige.
May it please your lordship, item number 5758. My lord, as per the last order of 25/6/2024, my lord had directed us to take Dusty. We have accordingly taken Dusty. My lord, this is a stay vacating application, my lord. There is an urgency in the matter. So my lord, my Dusty has already been completed. I've already filed an affidavit. 57, my lord.
So we have filed our objection, Lordship.
Objection they have filed because my
objection
service has been
is being
completed, my
taken,
lord. So objection they have filed because my service has been completed.
So let it come into.
Order stay vacating, my lord. It may be fixed for order stay vacating because service has
When
been
do you want?
to my lord on 3rd of August.
Okay, on
My
request,
lord, 6th of August, my lord.
on request made by the parties, list on 6th.
My lord, let it be fixed on stay vacating because the service has been completed. My lord, that is the order I want because my lord, otherwise again it will come for orders. Because the stay vacating application, my lord. And I have already complied with the Dusty service as lordship.
Have you filed your affidavit?
Yes, my lord, this is my affidavit.
Affidavit is there.
Yeah, is there on the record. We call for the requisition also in the morning. It's in the second file, my lord. It's been there. Second file. My lord, this is the one.
Okay, come to the thing. Is there, no? In both the writ petitions,
No, my lord. My lord had directed in the other petition, I was a respondent. In this, I was a petitioner. In 2884, Kalpana Goswami's estate. In the other, the steps has already been completed. It is their writ petition.
two eight eight four.
Yes, my lord.
This is your writ petition.
Yes, my lord, my writ petition. Lordship on 25/6 had directed.
Shamal and the counsel for the petitioner in WBC number 2884 of 2000. Peruse the affidavit filed by the petitioner with regard to service of notice on the respondent number
4, my lord.
4 by Dusty Service. The affidavit is accepted. And the notice on response number 4 shall be deemed to be complete. Mr.
K. Kashyap.
K. Kashyap, legal counsel, appears for the response number 4 in WBC 2884/2024. So, list this matter on when?
6th of August, my lord.
This
First day vacating.
in the admission college.
My lord. Much obliged, my lord. I highly oblige.